be coming along, and we'll get back to our normal full strength, I'm sure. Thank all of you for being here for what may well be the last meeting this session of this committee, and I know that brings great sadness to members and those of you who like to come to our meetings and have business here from time to time. I want to do something a little, I know we've got a full schedule and I don't want to prolong it, but I was thinking over the lunch hour that, you know, we're at that time when everybody's focused on nothing but what's going on in this building, getting our bills out, getting a bill out, are you going to sit down? But as I was saying, I think we get really preoccupied on this little world and forget that there is a greater world out there. And things like what happened this morning remind us that there is another world out there and that people are hurting today. I'm sure all of you are aware or have heard now about the great, great tragedy at Virginia Tech this morning. And I understand that the death toll is now up to about 22. And I'd like to begin this meeting with a moment of silence to honor the victims as well as the students and staff there. Thank you very much. One little housekeeping matter. I want to announce today we had a bill in here earlier this session, House Bill 397 by Representative Clay Cox. I have been talking to some of the members of the committee and others, and I'm appointing a special subcommittee that will look at that bill over the interim and report back to the full committee by the beginning of the 08 session. And I've asked to serve on that committee the following members of this committee: Representative Bearden, Representative Levitas, Representative Everson, Representative Abrams, Representative Lunsford, and I will chair that committee, and that's a committee on House Bill 397. And before we adjourn, I may have one or two other bills that I will put in special subcommittees for some intensive sort of work over the interim. And with that, Senator Johnson, I understand, is tied up, but we have our own chairman, Ron Stevens, here on Senate Bill 1, and I'll recognize him at this time.
Thank you, Mr. Chairman. This is Senate Bill 1 is a very, very simple bill. It's a one-pager. It corrects a loophole that's in the law having to do with convicted child molesters. This particular bill essentially says that, as a result of a situation that was down in my district in Bryan County, where we had a child that was being photographed unbeknownst to her. And whenever the parents found out about it, they were outraged, and even more outraged to find there was nothing they could do about it. Essentially, all this does is line 16 is the meat of the bill, which says very simply that it's unlawful for any person who is required to register as a sexual offender to intentionally photograph a minor without the consent of the minor's parent, and that's in any form of photography. And if the person does this, line C simply says that any person who violates this code shall be guilty of a misdemeanor of a high and aggravated nature. And, Mr. Chairman, that's the crux of the bill. It's certainly hope the members of the committee would see fit to move it forward.
And we have questions from members of the committee for the author. Questions from the committee? Okay. I'm sorry, Representative Levitas.
First of all, Mr. Chairman, thank you for bringing this. It's a great bill. My only concern goes to really the grammar. This may be a question better answered by legislative counsel, which is we've defined in line 14 through 15. It seems to me we've defined the word photograph as in the noun form, but we've used it in the verb form. And I just wonder, for purposes of clarity, if we need to do something to clarify that. If the legislative council does think it's a problem, I just wonder if we use the word in the verb form, I wonder if we have to have that match in the definition form. And Mr. Chairman, could I have would you allow me to ask legislative counsel to respond to that?
If she
so chooses?
I suppose it could say take a photograph, because you're right, it is a noun and a verb.
My only concern, and the only reason I bring this up is I would expect a challenge to this. I think it's an excellent bill, and I'm glad it's being brought. If we bring something under this, I would hate for it to be ruled either unconstitutionally vague or anything like that. But again, I don't want to be the one to hold up a good bill. If it's not a big problem, I don't want to create one, but it's just something that I would ask us to consider before we pass on it.
And if legislative council believes that's something we need to correct, I'll have no problem with an amendment.
I think it's a good point.
Appropriate time, but I think Mr. Chairman Franklin.
Thank you, Mr. Chairman. One thing, didn't we take up a similar bill to this earlier this year, a House bill? There was something with photographing. No, it wasn't possessing the photograph, because I remember the idea of intentionally photographing a minor without consent. So if I'm intentionally photographing Chairman Stevens, but in the background is Legislative Counsel Travis, and am I barred from photographing her without permission if she's a minor when I'm intending to photograph Representative Stevens? Like Representative Levitas, I don't want to challenge to this good law if we don't have it tight enough.
And I believe
my thinking, help me out, Jill, is that would be just a factual dispute. I mean, I think like any other crime, I mean, if it were accident, inadvertent, I think that's a defense.
So the defense would be, well, Your Honor, I was taking a picture of a movie star. That child just happened to be in the background. I was not.
And then it becomes simply, does the court or the jury believe you?
And, Mr. Chairman, if I may, I think the word pretty significantly intentionally is the key word there.
Further questions for the author? Maggie, you signed up to speak on this?
Yes.
Okay. Maggie Garrett.
Good afternoon. I'm Maggie Garrett. I'm with the ACLU of Georgia. And though I recognize the good intentions of this bill, I do think that there are some constitutional problems with it. And I also think that there's other ways to solve the problem that's been brought up today. The main issue for us is that the bill is very, very broad, and I think it's broad enough that it would be found unconstitutional. And let me just go through that process briefly. First of all, taking photographs in public is protected speech. In the same way that describing a scene verbally would be protected speech, taking a photograph is also protected speech, and the courts have held that. And so because it's speech, you have to apply the compelling interest test. So the first question is there a compelling interest? And here, I believe that the compelling interest that we're trying to seek here is to prevent harassment and sexual pictures being taken. So then the next question is this narrowly tailored? And I think that's the problem with the bill. This bill applies to much more speech than the speech that we're trying to target. We're trying to target when a person is trying to harass a child, or someone is trying to take sexual photographs, or even non-sexual photographs for a sexual purpose. But this bill encompasses much greater amounts of speech. For instance, it bars speech that picture is not taken by a predator or a pedophile. If you think about the situation that this created today with the sex offender law, if someone is 17, has consensual sex with a 15-year-old, that's considered a misdemeanor, but you also get put on the registry. So you would be subject to this rule. So the consequence of this rule is if you're a 17-year-old, you go to the prom, you can't take pictures at the prom unless you get consent from every single person. You can't take pictures at the football game unless you get consent of every single person, because you may be intending to take the picture of this child who you have a consent form from, but you are going to know that there are going to be other children in the picture. You actually, under this law, could not take a picture of yourself if you are a 17-year-old convicted of consensual sex with a 15-year-old. So I think that what really needs to be done here is the bill needs to be narrowed a bit in order to actually target the speech that you're talking about. Because I agree that if it's passed in this form, it will probably be struck down as unconstitutional. Then you'll be back where you started from. I think it makes maybe more sense to tighten up the bill, and then you'll have a bill that you can go forward with.
Questions for Ms. Garrett? Representative Lopez.
What would be your recommendation of how to tighten the bill?
Actually, I think Ms. Michaels has some language and that may be helpful.
Okay. Thank you, Mr. Chairman. Thank you.
Any further questions for Ms. Garrett? Further questions? Representative Green?
May have a clarification or double check on something.
I'm sorry?
A clarification on something.
Okay.
On the 17, 15-year-old. But as soon as we find that, I'll bring that up.
Okay. Any further questions for Ms. Garrett? Representative Mangum?
Garrett, so if you have the Romeo and Juliet exception in place, and you take a picture at the prom, that is covered by this law.
Are you saying to add a new exception to this law? As I understand the current sex offender legislation, or the bill, or the statute that's already in place, if you're a 17-year-old who has sex with a 15-year-old and it's consensual sex, though it's only a misdemeanor, you are still required to be on the registry for life.
Okay. So you would, okay. But if I'm not already on the registry, I could take a picture, but, okay.
Right, and I think that it's important to realize that this isn't, the bill as written, it's not taking the picture for a sexual purpose. It's not the child in a sexual pose. It's not taking explicit photos or anything like that. It could just be a kid walking down the street.
One other, Mr. Chairman.
Sure.
If I have not heard what Ms. Michaels may be bringing, but if there are more than 3 people in the picture, for example, just throw that out, not 2, but more than 3 or more, and it is not a sexual picture, would there be a problem with legislation in your estimation from a constitutional standpoint? Not to go one way or the other, but I'm trying to understand the scope of the constitutional infirmity, and that is, if we have 3 persons, I take a picture, very innocent picture, and I happen to be on the sexual registry, now I have a job taking pictures for the AJC. Some paper. And I take a picture, and I have at least 3 people in that photo, and I am prohibited from taking any pictures that have less than 3. Would there be a violation from your standpoint on that?
So what you're suggesting is in the legislation you would amend it to say a certain number of children. Is that what you're suggesting?
There are at least, I have concerns that if you're taking 3 pictures of these 3 kids, if you're on the sexual registry, you may do some bad things with just 3 kids, but I don't know. Let me withdraw that picture.
Okay.
Withdraw my question. I'll hear what Ms. Michaels has to say.
Without objection. Further questions from Ms. Garrett? Further questions? Thank you, Maggie.
Thank you.
Are you still researching the law books, Representative Bearden?
With great help from Ms. Fox.
I hope so.
promise you.
I hope so.
Y'all had enough of y'all over there, you might get a lawyer.
Don't you want to join this conversation, Representative Collins?
Wouldn't post it right now.
Sandra, you're not signed up. Did you have an amendment?
I think I am signed up. I'm so sorry.
Are you?
I thought so.
I'm sorry.
Okay.
I'm wrong. You are. Sandra
you.
Michaels.
Sandra Michaels, the Georgia Association of Criminal Defense Lawyers, and I think Daniel's making a copy of our proposed language. But, and I appreciate the opportunity. They were very kind in the Senate Judiciary about listening to us about some language changes. Thank you so much.
Did they make them?
Yes, they did make one. But I had an additional one which I think addresses a number of the issues that have been raised by Representative Levitas and Representative Mangum. They did take one thing about the consent part was some of the language we had asked that they take. But specifically, on line 17, and after the word photograph, we request that the words "for indecent purposes" be added. So the whole sentence should read, "It shall be unlawful for any person who is registered, or is required to register as a sexual offender pursuant to Code Section 42-1-12 to intentionally photograph a minor for indecent purposes without consent of the minor's parent." Well, I think it just have to be right there. And just leave it at that paragraph, because what my understanding and listening to the parents testify at the hearing about this bill is that this was a sex offender who went to this fast food establishment, I believe, and started taking photos of this young woman. And he was a registered sex offender. It wasn't like he was just taking pictures at a gathering and this young woman happened to be in the photo. He was specifically taking pictures of her for his own purposes. And throughout the code section on the sex offenders, almost every, even the phone calls you may recall where we did the, you did the law that was, you couldn't have, particular conversations with minors for lascivious purposes. There's always, as Maggie was saying, there's always an addition to the statement, you've got to have it for bad purposes. It can't just be an innocent taking. And I believe that this, the intent of the bill is to prevent a registered offender from taking pictures for improper purposes. And for adding the indecent purposes would resolve the constitutional issues. It would narrowly focus the bill on the prohibited behavior that the sponsor of the bill wants. It would be consistent with the rest of Title 16 regarding sex offenses. And it would clarify the bill and I believe make it a better bill. I can't imagine the sponsor of the bill wants to prevent taking pictures. I mean, you could take a picture of a group and there'd be or females or some kind of minor in there, and it wasn't the intent of the person to take the picture to take the photo for improper purposes. We also have to remember, and I think another bill you're addressing today, think about who is a registered offender. It was a wide net of people on the sex offender registry, and it's not all pedophiles or people that are going after young people for bad purposes. A lot of them are status offenses. So I would respectfully request that you add the phrase for indecent purposes on line 16 after the word photograph and put a period after the word indecent purposes, and that way you would have all the issues.
Chairman Franklin.
Thank you, Mr. Chairman. Did you offer this amendment to the Senate when it was in committee? What did they handle that?
They didn't agree. I mean, they obviously didn't take it but they did take the part. We asked for, well, if you're not going to do that, put without the minor's parents or guardian, because the classic, the Christmas photo. Here's Uncle Tom taking the Christmas photo. I mean, he'd just break the law if he took the Christmas photo. But the whole point is, you don't want a sex offender or the pedophile taking photos of minors for whatever their own purposes. You don't want to just be an innocent photo and make that person a criminal just because they're taking photos and a minor either happens to be in it or it's a relative.
Isn't that why the word intentionally is in there?
Well, no, I mean, because you're intentionally taking a photo.
But not of the child.
No.
If it's Uncle Fred, I'm sure he's got Mommy and Daddy's permission to take that photo at Christmas time. I'm not seeing that as a problem. No,
it's not the intentional taking the photo that's a problem, because when you take you're intending the consequences of your action of pressing the button to take the photo
Intentionally photographing a minor. Which is what
for
it says.
bad purposes. It's the for bad purposes is what you don't like, not just taking a photo.
But if it's intentionally taking, I might not be communicating very clearly, Mr. Chairman.
Or maybe-
It seems like if it's intentionally photographing a minor without the consent of the parent, if you're taking a family photograph, obviously the parents are consenting, or they wouldn't have even invited you to the house. But it seems like that intentionally is the driving force that we had discussed when I raised the question when Chairman Stevens was in that seat, and it seems like that is taken care of.
No, I don't agree. I think a better example, maybe the Christmas photo one's a bad example. You asked me what I talked about in the Senate. A better example would be someone just taking a photograph. Say they're out taking photos out in San Francisco at the Golden Gate Bridge, and there just happens to be a group of cheerleaders or something crossing the bridge. Well, that person just broke the law. Now, if they were taking a group of the cheerleaders' photo with a telephoto lens because they really wanted to hone in on the cheerleaders, that would be taking the photo for the indecent purposes. Just taking a photo and a minor happens to be in the photo is not the purpose of the bill. I mean, the intentional act you're talking about is the taking of the photo. The intent goes to the act. What you want is the intent to be for the bad purposes. The criminal act shouldn't be the taking of the photo. The criminal act should be the taking of the photo for the bad purposes. That's what Maggie's talking about in the constitutionality of it, and that is what, if you look throughout the code section and you look at the laws that have been passed, it's got to be for a bad purpose, not just an innocent intent. It's got to be a bad intent.
Representative Abrams.
I have a scenario. Without your language, just using a plain reading of Section B, isn't it true that a parent or guardian could be complicit in the taking of an indecent photo of a child without consequence to the photographer? So that if you read this language as it's written, if they intentionally take a photograph of a minor with the consent of a parent, so a parent can be complicit in the taking of the photo even if that photo is for indecent purposes, unless we amend the indecent purposes and unless we remove the ability of a parent to give consent for those indecent purposes.
Correct. Exactly like that situation Gwinnett with a father.
Thank you.
Yep.
Further questions of Ms. Michaels? Further questions? Thank you, Sandy.
Thank you.
Further questions or discussion by the committee? I think that's all we had signed up to speak on this. Representative Lunsford.
Yes, sir. This parliamentary require the chair an opinion or could. So this means if you had someone who was required to register as a sex offender that happened to be a professional photographer and goes out to an athletic field and the team hires him or her to take pictures of the sports team, the parents aren't there and haven't given consent and they shoot the photographs of those teams, they've just broken the law if the teams are minors?
I think that's a fair reading of the bill. Yes.
Okay. Thank you, sir.
It would not be the team's consent under this bill, it's the parent or guardian. Representative Abrams?
At the appropriate time, I'd like to
Okay. Representative Levitas had asked earlier, so I'm going to recognize him, and then I'll come back to you. Further questions or discussion? Representative Levitas.
Mr. Chairman, I would make a motion to amend at line 14, after the word means, add the words to take, and the rest of the sentence in the paragraph would read as it does now, just to change the purpose of the bill. The amendment is just to make it a verb instead of a noun in its current form.
Is there, we have a motion. Is there an objection to that amendment? Is there an objection? Hearing none, that will stand adopted. Representative Abrams.
I'd like to make a motion to amend line 17 to insert after the word minor the words for indecent purposes to period, and then to strike the remainder of line 17 and line 18 and to renumber. The purpose for my amendment is that I think this unintentionally creates the opportunity for parents to be complicit in the exploitation of their children, it allows a parent to give permission to allow a photographer or to allow a sexual predator to take a photo with the parent's permission, and that has happened more than a few times in the state of Georgia. I think the language recommended by Ms. Michaels, adding for indecent purposes, achieves the underlying intent of this bill, which is to stop sexual predators from taking pictures that will be used for prurient purposes, and that I think it's important that we not allow parents to give consent and to be complicit in the exploitation of their children.
Okay. Is there a second? Second. We have a motion that we adopt the Abrams amendment, which would, after the word, on line 17, after the word minor, add the words for indecent purposes and then put a period. And strike the remainder of that line as well as all of line 18. Any question about the amendment or the motion to amend? Now I want to recognize the author, and I didn't recognize you on the Levitas amendment because I thought that was a technical improvement.
It is, Mr. Chairman. That one, I have no problem with at all. However,
this one gets into content a little bit.
Yes, it does. This one would essentially not cover the problem that we had in Bryan County. That particular individual, his intent, even though he was a convicted sexual offender, with the initial picture, was, we don't know what his purposes was, and it was not for indecent purposes. And I'll keep in mind, ladies and gentlemen, whenever somebody's convicted of an aggravated sexual nature, we already know the conviction is there. We don't know what their intent is whenever they take the picture of this minor. However, it can be altered. Everyone knows that it can be altered to the person who's taking the picture's benefit. I would object to that amendment, and I would hope that you would vote against the amendment.
Is there any discussion, any further, question, Representative Levitas?
I don't know whether it would help or not, but would it help if there was a substitute motion that added the language or retain? In other words, what it would do is prevent somebody from either taking the initial photo for indecent purposes or retaining it. So even if that person took the picture for non-indecent purposes, for decent purposes, whatever the correct terminology is, but then held on to it for indecent purposes, would that address the concern? Would that have covered the situation that you experienced in your county?
No, because if you take it with a camera, which was the specific case in the in Bryan County, it can then be transmitted, everyone knows, to somebody else's phone and then deleted out of yours or to another medium. So I don't believe that would, even though it's a well-intended amendment, I don't think it would serve the purpose.
Now, I think I may be a little bit confused, but are you worried about it being transmitted to somebody else's phone and then getting back to the photographer who is the person convicted of the sex offense?
Or transmitted to another medium that's not on the person themselves. What we're trying to get here is taking the picture by the sexual offender himself, intentionally, any person that's under 18 years of age, without getting the parent's consent. And that's about as plain as you can get.
Maybe I could ask it, and again, I don't know if I'm getting at it or not, but if you add the or possess, wouldn't that cover no matter how it gets back to that person for them to possess the photo, to take it or to possess it? I don't know if that would help or not, but it seems like if the issue is they're transmitting and getting it back, if they possess it, then they would still have the same violation if they were possessing it for indecent purposes.
And I appreciate that. I'm just not sure that where the problem might be with the person taking the picture to begin with, without somebody's consent. We don't know what his intent's going to be until he takes the picture, or even what he does with it. But your amendment to the amendment would be at least better.
Representative Collins.
Thank you, Mr. Chairman. Sort of a couple of questions and comments here. One, I understand, I think, briefly what Representative Levitas was trying to do. I'm not sure we're setting up something that could even halfway be enforced with that. The other issue that I understand what I've been listening to concerning the unintended consequences of this bill, and I think that's what's the underlying thing here. What is the unintended consequence of what we're having? But I think going back just to the plain language, as I respect Representative Abrams said, intentionally photograph a minor without consent. And I've heard examples of the Golden Gate Bridge photographers and everything else here today. And the concern that I'm having here is just simply going back, as constitutional law sometimes does, is actually reads the letter of the law of the bill here. It says intentionally photograph a minor without consent. The issues of photographing a group and it being used, I mean, those are issues that we have. I think going back to the intent of the author and the intent that is seen here is such as the example given in your county, or the intentional, what I'll take from the intentional photographing of a minor is that whether it be, and again, trying to get into a person's head, you talk about leaving it wide open there for whatever purpose they may be taking it. I think it's been fairly well documented, and the issues that for a sexual offender, those you're not going to know those issues. And I think the issue that I have here is let the bill stand as is, reading-wise, because we're looking at a specific instance, not unlike Representative Lopez, I understand taking a football photo. We're dealing with is taking a minor. This tends to be a focus here of this bill. That's where I understand the unintended consequence, and I understand the objections Ms. Abrams may have, but I seem to think that even adding in this language, we're taking away from actually the intent of the bill, but also not really overwhelmingly helping it, except adding language that could easily be debated in court many, many times over. So, if we're going to have an issue, which I think was brought up earlier, let's leave the language as is, debate it on the merits instead of adding in language that will definitely be challenged on this, whatever this indecent purpose may be. And is that not true, Ms. Stevens?
Yes, it is. Thank you for eloquently pointing that out. It was. Thank you.
Further questions? Representative Abrams?
With all due respect to Mr. Collins, I think the intended consequence of a bill should have general application and should not be made to attack a specific purpose. We do not have one single instance of photographing minors. You have a number of opportunities where that happens. And if we're going to create law, then law should have general application. That general application should take into consideration the fact that you have a myriad number of opportunities to take a photograph. You have a myriad number of circumstances where a person may legally and lawfully and certainly well-intentioned take a photograph. And my concern is that this bill lacks specificity. We don't specifically limit sexual offender to not include status offenders. We don't specifically limit what constitutes a parental consent. My concern is certainly in the state and DeKalb County, the fact that you had parents consent to the exploitation of their children. This exempts them from this bill. They can certainly continue to participate, and unless defects happens to catch them. My concern is this bill, whether the intended consequence may be a very noble consequence, but the vehicle to achieve that, I think, is fatally flawed. I think the ACLU brings a number of very, very viable challenges. I think left on its face, this is an even broader opportunity to strike this bill down, and at least by narrowly tailoring how this applies, I think you have a better chance of survival.
Further discussion? Further discussion? All right, the measure that we have on the floor now is the Abrams amendment. Any further discussion? Representative Lopez.
I have a substitute motion.
State your motion.
Motion, and I may need legislative counsel's help to perfect this, as I often do. It would be to come up with another definition. So it would be either a new paragraph, subparagraph A3, that is the same language as existed before the amendment to paragraph 2, so that it would read, photograph means any picture, film, or digital photograph, motion picture, film, videotape, or similar visual representation or image of a person. That would be part 1 of the motion, would be to add a new subparagraph 3 with that language. And then to add at the end of line 17, after the word minor, insert the words for indecent purposes, strike through to the period, and insert the words or to possess a photograph, or to possess the taken photograph. And when it's appropriate, I'll explain the intent of my amendment.
Is there a second? Is there a second?
I'll second it, just for discussion's sake.
Against your better judgment.
Sometimes, never mind. All right. We're now on discussion on the substitute motion by Representative Levitas. I'm not going to try to restate it. Does anyone?
I'm not sure I could.
I'm not sure you could either. Does anyone, Representative Lunsford?
Mr. Chairman, this question to the chair, if I could. I'm thinking that we can actually get to where we want to get without damaging the legislation if we left the paragraph like it was, and then we put in another paragraph starting at line 16 and just repeated it again, but do it as Representative Abrams said, for indecent purposes, and scratch the rest of that line. Then what we've actually said is you can't take the photographs, and then you can't take a photograph for indecent purposes, even with parental consent. So we've now taken care of the DeKalb County issues with somebody from that, and we probably taken care of this issue as well. So with or without parental consent, you can't take an indecent photograph. If that makes any sense, I'm not sure exactly how to word that.
You want to take a stab?
I'll second yours too.
I second Stacy.
We saw that paint job.
The concerns, and I understand what Representative Abrams said, the concern is that with this language, a parent could say, hey, I know he's a weirdo, but I'm going to let him take pictures of my kid. I'm going to give parental consent. He hasn't violated Georgia law, or she hasn't violated Georgia law, which I think is wrong. I have 7 kids at home. I'm not real fond of sexual predators or sexual offenders, I can assure you, especially when it concerns minors and children. So I'm trying to cover both ends of the gamut so we don't damage, Senator Johnson's bill, but at the same time we don't allow a loophole where a parent can give consent for somebody to take pictures because that parent has a mental problem themselves, allowing that.
Jill, can you assist Representative Lunsford with his language?
Frankly, I'm not understanding what the goal is. Sorry.
Mr. Chairman, with your permission, I'll restate it.
Sure.
And go through it. If we left everything as it is, and all we did was we took, say, at the end of line 19, beginning of line 19, we bumped it down and we repeated line 16 and 17 out to the word minor for decent purposes to stop the line there. So now, even if the parent gives consent, it's against the law. And we
so you're wanting to have one subsection B that says you can't do it without consent, and then another subsection that says
can't do it with consent.
For indecent purposes.
Correct. Does that make any sense?
Yes. You could say it shall be unlawful, I'm reading on line 16, unlawful for any person who is required to register as a sex offender pursuant to 42-1-12 to intentionally photograph a minor without consent of the minor's parent or guardian, or to intentionally photograph a minor for indecent purposes.
That's fine.
I think it's going to be a contentious issue, but that's my idea.
Second at the appropriate time.
Representative Abrams.
Certainly, prior to having a motion, I would suggest that my attempt is to solve 2 problems. One is parental complicity and exploitation. The second is the rather expansive expansive definition of sexual offender under Georgia law. I think, with all due respect to Mr. Lunsford, his proposal, by leaving subsection B intact, you still permit, or you still create such an expansive reading of sexual offender as to exclude a number of persons in lawful activities from, number 1, exercising First Amendment rights, number 2, simply behave as using the example of that Ms. Garrett proposed, which is the 17-year-old who was at the prom. This language is so vague as to, I think, capture a number of persons we don't intend to capture, and I would be opposed to that motion should it come to the floor.
All right.
question only, sir. I'd be happy to withdraw my motion, my seconds, and my presence.
I'll let you withdraw your motion, but I need for you to be here to live to play another day. Do you have something? Okay. Who had their hand up?
I do.
Representative Collins.
Mr. Chairman, and this is a question for either legislature.
Now, we're on discussion on the Levitas substitute motion.
I know, and it still includes the words for indecent purposes. Am I correct on that? Kevin, come on. I know.
I was in conference with my esteemed colleague.
That motion again.
All right,
Does it still have for indecent purposes?
yes.
Tell me how you police that. How are you going to prove for indecent purposes?
Well, the same way that you would have to do that for any kind of indecency crime, whether it's child molestation or enticing a child, those have the word indecent in them, and those have been upheld through constitutional challenges. What my particular amendment would do was to set it up two ways. One is you couldn't take the photograph for indecent purposes, but to address the concern that the bill sponsor raised is to also address possessing. It doesn't matter how it gets back to you. If you either possess it or you take the photo, whether you have the original intent for indecent purposes or you subsequently have an indecent purpose for possessing it, that would be the intent of the substitute.
Are we in, Mr. Chairman, can I ask another?
Please.
Yeah. Are we in some way saying then that if it, and I'm just going on your own language trying to add that if the sexual offender intentionally photographs a person, that he's doing it for indecent purposes?
I'm sorry.
I mean, by adding this language, you're now saying that sexual offender, whoever's on the list, if he takes a photograph, he is doing it for indecent purposes. Because there seems to be because without saying up front, and again, my concern here goes back to why this bill was brought, to keep the pictures from being taken to start with. Because bringing it back, the indecent purposes would have to be proved, seemingly to me, on an entirely different issue, on an entirely different case, and then bringing it back to this language here. Instead of the way the bill was authored was to keep the pictures from being taken to start with. And that's been my confusion with the multiple of amendments, is going back to this issue right here, because it seems like now we're saying for indecent purposes. Well, the only way we could get at the indecent purposes is to bring it in from an indecency standard or something else, not this issue right here. So I'm with the multiple of amendments, I'm trying to say, okay, what's the intent are we trying to perpetrate here on the state?
As I understood Matt, respond to
yes.
As I understood, the intent of the bill was to deal with the situation that we heard about, and I don't think it matters what the purpose was originally. We don't want a sexual offender to possess or take a picture for indecent purposes, period. So it doesn't matter up front what it is one way or the other. What matters is, and this was always true of any criminal act, you have to go to the state of the mind of the person taking it. And so if they've either taken it for indecent purposes or they possess it for indecent purposes, but what it wouldn't capture is that myriad of other things we've talked about today that have to do with a legitimate or non-intrusive reason for taking the photograph. Family picture, sports team that Representative Lunsford used, any of those purposes. So that's the intent of the substitute, is to try and protect the offense without making it either unconstitutionally vague, which is what I think it is as presented, or to lose the point of the statute by trying to perfect it.
Representative Bearden, and then Vice Chairman Mumford.
For my good friend, Representative Bettis, that follows up on Representative Collins' question, what act would he or she have to be performing to make it indecent act? What would the police have to catch them doing to make it indecent with the picture? And that's where I think it's implicit.
I mean, what I could point my good friend Representative Bearden to is again these same statutes. If you look at, for example, 1668 public indecency statute, one of the prohibited elements of conduct is a lewd caress or an indecent fondling of the body part of another. Same thing with child molestation. I mean, that's going to be a trier of fact determination. I don't know that you could put a list. In fact, I wouldn't want to make it a list because might make that an exhaustive list. I wouldn't want to rule out any particular conduct that a jury might find through the appropriate standards to be indecent.
May I follow up with that question? Not to sound harsh, but I'm actually trying to get to the subject matter. So if he has the picture in hand and he's
naked in the parking lot, following stuff, is that the indecent purpose then? I mean, is that what we have police to try to catch?
If I'm on the jury, you hang them. If I'm on the jury, you hang them. But that's me. But right. But that's. I mean, I guess my point is this: is that if you, yeah, I sure did. But I guess my point is that if you're not protecting it for indecent purposes, I mean, I assume that we all want to prevent anybody from possessing or taking a photograph for indecent purposes. I don't think you can, and none of these other statutes like public indecency or child molestation tries to statutorily define what indecent is, because that's going to be at the community standards. So I don't know that you can do that. But unless what we want to say is we're going to prohibit all photographs, we're going to encompass all of these just for the purpose of addressing this subset, then then you would not want this language. If you wanted to tailor it to address the problem at hand, that's what this would do. But if you just want to make a broad brush, you would vote against this.
Still my friend, but I disagree with you on that.
Vice Chairman Mumford.
I was just going to back up my friend, the former assistant solicitor from DeKalb County, Mr. Levitas. Well, I think what he was trying to tell you was that indecent purposes is a term of art that's already in the code that actually has case law developed and definition, I guess you could say. And enticing a child for indecent purposes being a primary example. And I don't know that it helps you any, but that's what I was trying to get to.
Further discussions? Further discussions or questions? All in favor of the Levitas substitute motion, please indicate by raising your right hand.
Can we attach 336 to it?
All opposed? Okay. So it's been adopted? Oh, it failed. I'm sorry. Okay. That brings us back to the Abrams motion. Further discussions or questions on the Abrams motion?
Quick question.
Representative Bearden.
The author is, you're opposed to this amendment also, correct?
Yes.
Okay. Further questions, discussion? All in favor of the Abrams motion to amend, please indicate by raising your right hand. All opposed? Abrams' motion has been adopted. Okay, the Abrams amendment has been adopted. All right. Further questions or discussion on the bill? All in favor of passing Senate Bill 1 by committee sub as amended, please indicate by raising your right hands. All opposed? And we'll send that on with a due pass recommendation.
Thank you, Mr. Chairman. Ladies and gentlemen of the committee.
Senator Staten, how long did y'all take on Senate Bill 1 in the Senate?
I don't think it was as long
Not
as
that
you
long?
did, Mr. Chairman.
Okay, I think you were next, and then Senator Fort came in after you. So if you want to come on around, Senator Staten on
Senate Bill 40, Mr. Chairman. Thank you very much for being long-suffering with my bills.
Senate Bill 40, calling Senate Bill 40, Senator Staten.
Thank you, Mr. Chairman. Senate Bill 40 is a result of a great deal of work over the last year.
Hold on just a moment.
Certainly, Mr. Chairman.
Got a little rumbling here. Okay, let's give the senator some attention. Thank you very much. Continue.
Thank you, Mr. Chairman. As a result of a good bit of work over the last year or so in looking at election law, as many of you or all of you will be aware, obviously the photo ID bill that was passed 2 years ago and again last year is in the process of making its way through the courts. But along the way, we have wanted to take a look at the absentee balloting process in our state. And this is a bill that we have worked with the Secretary of State's office, the State Board of Elections, and others in order to make a stab at doing something in Georgia to toughen our laws with respect to absentee balloting. There are actually two bills that we've done. One is here in your committee, Mr. Chairman, and then there is another bill that will be heard later this afternoon in another House committee. But this is a bill that is, it passed in the Senate committee, I think, without opposition. It passed on the Senate floor without opposition. There was bipartisan support for this bill. We have a letter, which perhaps you have a copy of, which is from the Secretary of State on behalf of the State Elections Board in supporting this committee. And even though I won't necessarily speak for them, they may be here, it's my understanding the League of Women Voters has also come out in support of this bill. They spoke for the bill in the Senate committee. If you look through the bill, the changes that you will see primarily have to do with the penalty for fraudulent activity with respect to absentee balloting. And it is taking the penalty to a higher level. Previously in the law, there were places where it was considered a felony. There were other places where it was a misdemeanor. This bill will...
We have two of them. The Kelsey number we working on.
Actually, I'm working off the committee substitute, which
3744S.
Yes, 3744S. No problem. Thank you for clarifying that. But you will see previously there were places in the law where certain acts would be considered misdemeanors, others would be considered felonies. This bill fairly consistently now throughout will simply raise the bar for absentee balloting fraud. It will be considered a felony, and upon conviction, the sentences typically are not less than 1 or more than 10 years, or to pay a fine not to exceed $100,000 or both. It has been argued in the last several years that the bulk of crime relating to election fraud in our state has to do with absentee ballots. I've never disagreed that that is at least where we find most cases being raised or prosecuted or examined. I think that's actually true. But I do know from talking to various people in the Secretary of State's office and at the State Board of Elections, it's been a very hard thing to prosecute because, again, as a misdemeanor, it's been taken very lightly, and it's very hard to gear up to do that. So they support this bill because I think it is a good thing for us to make sure that people are aware that in Georgia we do take election fraud seriously. And if someone intentionally seeks to violate our laws with respect to election law and the absentee balloting process, it will be taken seriously. And if they are prosecuted and convicted, they can be guilty of a felony violation with pretty significant consequences. Mr. Chairman, I'd be glad to answer any questions from any members of the committee, but that's just a little bit of background on this bill.
Thank you, Senator. Questions from the committee? Questions from the committee. Representative Mangum.
Can you point specifically to the section referring to the Absentee Ballot Act? I'm looking at this, unfortunately, for the first time. I've gone through it. I see the penalties,
Yes, certainly, Representative. If you'll just begin on page 2, you'll see that this is the affirmation of an elector that has to be given, and That's the first change. And you are correct. There are other things where, again, the bar is raised here. It has to do with how you assist people with their balloting. There are some circumstances where people have been prosecuted because they have taken advantage of a situation where they were assisting someone with their ballot. They've broken the law in terms of voting for someone or in the way they assist that person. Those penalties are also increased. Page 3. Page 3 has to do if you register as an elector knowing that you don't possess the qualifications required by law. If you knowingly give false information, that is taken into consideration here and again becomes a felony. Anyone who if you look on page 4, it just continues on with respect to how records are kept. If anyone intentionally destroys those kinds of things, or records or ballots or ballot cards or things that have been submitted, if someone is trying to manipulate that process, it becomes a felony. There is on page 4 also if someone begins to try to willfully intervene in someone lawfully voting, knowingly deposits fraudulent ballots in the ballot box, or tampers with election lists, voting machines, those kinds of things, it is increased. On page 5, you'll see again a couple of occasions. This has to do with attempting to influence someone. This occurs in this can occur at the ballot box, or there are occasions as well with the absentee balloting process in terms of giving lawful assistance to someone else when they're voting. There are laws with respect to what is appropriate and what is not. Voting more than once. On page 6, any person on page 6 who votes or attempts to vote by absentee ballot at any primary election of this chapter who is not qualified to vote shall be guilty of a felony. That one specifically has to do with absentee balloting. Some of these things, as we've looked at the process, have been requested by the State Board of Election and the Secretary of State's office in trying to bring consistency to the way some of these things are treated. Page 6 and following on page 7, again having to do with tampering, making fraudulent entries or casting fraudulent votes or destroying ballots or lists, tampering with machines that may count, or any of these kinds of things. Again, the bar is raised, guilty of a felony. In that case, I think it was already a felony, and there's been an adjustment here just to be consistent with respect to the sentences that may be imposed. So again, it covers a lot of areas where there's the potential for fraud, and we do have another bill that deals also with absentee, more specifically with the activities of handling ballots, and that'll be heard in another committee later.
Thank you.
Further questions? Representative Beard.
One other, Mr. Chairman.
Go ahead.
Do you have any specific information as to any specific wrongful acts? I can envision many. Is it on? I forget the terms. Is it on? Yeah. Are there any specific acts to which you are trying to get after? Specifically, do you have any data showing any election fraud that you are specifically after? Because most of it, we've had some rounds on this, and for one, I do want to have protect the voting process, but at the same time, I be very candid with you. I don't know whether this chills it or not. I don't know. And I don't know whether anyone else is going. Is anyone else going to be testifying today on this? One other person.
She's the colleague.
I also be happy to fill that question.
Okay, but I'm concerned that we have some. I am wanting to protect the voting process, and thank you for bringing this legislation.
Sure. Well, there are some people here from the Secretary of State's office. You know, in terms of examples of fraud,
yes,
I think, and again, I'll be glad to let them speak for themselves, but I think that there are two areas here at the state level where these kinds of things are prosecuted. One is through the Secretary of State's office. They do have examiners, and I think they can testify to the level of activity that they deal with in any given year or through any given cycle. It's my understanding from meetings with the Secretary of State that there is probably more than we realize. There are things that are brought to them, and they are asked to investigate. And part of the problem is, again, when things are taken so lightly, or it's a misdemeanor or a slap on the hand, or there's nothing really substantive that they can do, it's not always been the case that they follow through with it. The other place is at the State Board of Elections, and I think if you follow their proceedings, you will find that, and I don't think I'm misspeaking, just about every time they meet, there are various cases that are being examined or processed that they look at. And a lot of times the questions or concerns are in these areas. What happens at the polling place is sometimes very difficult to know about. I mean, someone can do that and be gone, and there's no one really there to challenge it, or in some cases to even know that it's occurred. But the goal of this, in my opinion, and certainly my reason for being involved, is that I do think, given what has happened in our country over the last several election cycles, when you look, even if we look outside our state, what's happened in Washington State, and Ohio, and Michigan, and Florida, my reason for being involved in this, Representative, is frankly, I think it's enormously important that we protect the integrity of the electoral process. I think the last thing we want to happen is for Georgians or any citizen in this country to think that the principle of one person, one vote is not taken seriously, is not protected, and that they come to have the feeling that our elections are not free, they're not fair, they are not without fraud, and those who would seek to have their votes count more than others. So if this helps in some way to give them another tool, to take this seriously, to be able to prosecute it when it warrants prosecution, when there is serious abuse and fraud, then I think it's probably a good thing.
Sir, you may not be able to assist on this, but I will say it just so that whoever comes up and address it. I am very concerned about the situation where you have little old women who are assisting other possibly feeble or older persons, that this statute not be misapplied so that it will chill their ability or a desire to assist others in voting. And that is I am personally aware, and so whether it prejudices me, but I think I am one that I had an opportunity in some voting rights litigation, and I had the awful occasion to be called by someone down in Meriwether County. I'll never forget it. And these elderly black women were being charged for voting fraud. And it was simply assisting people to vote. And unfortunately, a very well-known attorney that I respect, that I've had litigation on the other side, on the same side with, was representing the opposing side to persecute these little black women. And what it did was, it forced people not to want to do anything. And I just want to balance not chilling that. And I do know that, I see this. Is it existing law right now that you cannot assist more than 10 people in a non-federal election?
I would need to ask
We're being told yes by the Secretary of State.
I would assume
guess,
so.
And someone else can probably answer that question. I know that you may not be able to even address what I just said, but I am concerned whether it's little old black women or little old white women. I just want it to be not used for a political agenda to chill a particular election coming up, as we have seen in some situations where, I mean, in this particular election coming up, people had traffic stops. In fact, that may be something. We shall not have any traffic stops on a doggone election. And Secretary of State somewhere, I am very concerned about that. There should not be a traffic stop, one of those, what do you call that?
Roadblock.
On an election day. That is preposterous. In this particular situation I'm thinking of, they had I mean, it was all kind of crap on that election.
And on the World Wide Web.
Okay, in this instance, would your people oppose a prohibition? God, I'm sorry. I am concerned about that issue, and I don't know whether it's appropriate in this particular legislation, but I am.
Are we bothering you?
I'm sorry, I'm turning this off. It's off.
I don't know if that is something that fits into the code sections that we're dealing with here or not. I would certainly agree with your concern about that particular phenomenon, wherever it may be, and my guess is that more often than not, that's a local kind of thing.
That's my concern.
Yeah.
It's local people who are manipulating the law to try to have a particular outcome in an election. And I am concerned that we won't have certain people indiscriminately prosecuted under a law, and it may be not.
Well, again, the Secretary of State's office may be able to talk to you better about prosecution issues. I'm not involved in that. I certainly do think that one must be mindful of all the things that you have mentioned. I would simply say that I've been very proud on this particular bill to this point. It has been bipartisan. We worked in the Senate committee with Democrats and Republicans on that committee to craft an appropriate level of what the response should be. And as I mentioned to you, it passed in the Senate without opposition, without a single vote of opposition, and that was not the case with the photo ID. So again, my goal is to make sure that we do, in Georgia, have elections that are as free from fraud as possible and from the kinds of abuses that I hope this will get at.
Thank you, sir.
Chairman Franklin.
I'd like to be recognized for making a motion.
And it's my understanding, if I might just say, Mr. Chairman, I believe Representative Lunsford has agreed to carry this bill. Am I misspeaking? Yes.
Do you want me to? I'll make an announcement after this if we have time. Chairman Franklin, did you ask a question?
Yeah, I said I'd like to be recognized for making a motion.
We have some that have signed up. Were there further questions of the author? Representative Lunsford.
Sorry, Mr. Chairman. To help my colleague, Representative Mangum, feel a little better, if you look at Section 12 of the bill, that includes your poll workers and those assisting those to vote. On line 35, you'll see it was changed from misdemeanor to felony. But if you look at Section 13, you'll see that on the following page, that discretion has been given back to the trial judge to convert it right
That's
to
right.
a misdemeanor again. So they actually haven't changed the punishment penalty, in theory, against the poll worker or someone who's assisting someone to vote.
Thank you.
Okay. Jennifer Owens, League of Women Voters.
Thank you, Mr. Chairman. I'll be brief. I will address a few questions that have come up. My name is Jennifer Owens. I'm here on behalf of the League of Women Voters of Georgia. It's my pleasure to be here in support of Senator Staten's bill. I appreciate the committee giving time to hear this bill today so that we can get, hopefully, out this session. We are supportive basically on a number of points. The two most important being that this strengthens the penalty for absentee ballot fraud, which is probably the most common case that comes before the State Election Board each meeting. It does so without restricting access to the process, which we greatly appreciate, and again, thanks Senator Staten. It also upgrades and strengthens the penalty for voter intimidation, which is another issue that we hear a lot about in the newspapers, and I think addresses perhaps might go to the traffic stop example that was brought up. Representative Mangum, in response to your two questions, one being, if you look, page 7, section 12, the piece dealing with the poll officers or poll workers, you'll notice that pretty much all of those conditions include some willful intent language, and I think that will probably address your problem. And then I also wanted to mention, as far as specific cases of absentee ballot fraud, probably the one that we're most familiar with is a case that came out of Dodge County in the early 1990s, and that was an instance of people voting through the absentee ballot process, people who had passed away, I think getting names off gravestones and things like that. And this, again, would upgrade that from a misdemeanor to a felony, which we think further secures the process. Again, we're in full support of this bill. We appreciate your time, and I'm happy to address any other questions that you may have.
Thank you very much. Questions from Ms. Owens? Questions from the committee for Ms. Owens? Thank you for being here.
Thank you.
The Secretary of State's office want to weigh in on this?
Very briefly, Mr. Chairman. Thank you, Mr. Chairman, members of the committee. My name is Rob Sims. I'm the Deputy Secretary of State, and I apologize for not signing up on the sheet as it went around. It sneaked by me when I came through the door. To Representative Mangum's points, I'd like to make a couple. First, the points are very valid and very much a concern of the Secretary of State, and something we have talked extensively with Senator Staten on. I think there's two considerations to make. First is that this bill does not create any new areas of prosecution, and what it is attempting to do is bring some consistency throughout the code for voter fraud, voter intimidation, and things of that nature, which leads to the second point, and really where Secretary of State Handel comes down in support of this, and that is the medium of voter fraud should not dictate the seriousness or how important it is to prosecute it. Today in the code there are sections where voter fraud, say in person, is punishable by a felony, but absentee ballot voter fraud is punishable by a misdemeanor. So the real purpose of all of this is to get to some consistency across the code so that all voter fraud is treated seriously and consistently throughout. For your question about the elderly women in Meriwether County or that as an example, I think there's as you can see in the code, as you recognize, that there is a provision where the lawful assistance of those who are elderly or unable to vote, be disability or handicap, is provided for in the code today, and that's certainly not going to be infringed upon by this bill. And I guess if there are any other questions that might be directed to the Secretary of State's office, I'd be happy to answer them.
Questions for Secretary of State's office?
My only concern is, where would such a prohibition, where would it be a good, the issue of having traffic stops? There shall be no traffic stops on Election Day. If you want to have them the day before. I mean, where should we have that legislation?
Well, I'm kind of reluctant to offer legal advice in a committee full of lawyers, but I would make this point. There's a section in the bill, in the code section today, that deals specifically with voter intimidation. And in my opinion, you could certainly make a very strong and rational argument that the types of voter stops you're referring to would definitely be under the guise of voter intimidation. So that could be an area in which you could pursue it. There would also be, in my judgment, some federal issues as well in civil rights law and voter rights law, as far as if in fact those traffic stops are being used to repress the vote or suppress the vote, and to evict that kind of an outcome in the election, that would be another avenue as well.
Thank you. Further questions? Further questions? Thank you very much, Mr. Sims.
Thank you, Mr. Chairman.
All right. I think that's all we had signed up to speak. Any further discussion? Excuse me?
I'd like to move to pass by substitute.
I have a motion.
Second.
We have a motion now, move in a second, that Senate Bill 40 be given a due pass recommendation by committee sub. Is there discussion on the motion? Is there discussion on the motion? All in favor of the motion indicate by raising your right hands. All opposed? We've moved it out.
Thank you very much.
Senator Douglas, that bill is not in this committee.
It's not here?
I just checked.
All right.
It's in the Civil Judiciary Committee.
Who's chairman?
Representative Willard.
Willard. Okay. All right. Thank you, Mr. Chairman.
Mumford, there he is. Okay. Senator Bullock and Senator Ford, I've just been taking people in the order in which they arrived. Senator Ford, if you would come around, and Senator Bullock has two bills anyway.
Okay.
We're on Senate Bill
258. Mr. Chair, members of the committee, Senate Bill 258 is a version of a bill regarding the sale of dope candy, what I call dope candy or marijuana-flavored candy, on, I believe it's subsection D. Subsection C, it shall be unlawful for any person knowingly to sell, deliver, distribute, or display for sale, or knowingly possess with intent to sell, deliver, distribute, or display for sale any marijuana or hemp-flavored candy in the state of Georgia. And subsection D sets out the penalties for that. Misdemeanor on the first offense, and on the second or any subsequent offense, it would be a felony. Punishable by 1 to 5 years, and by a fine of not less than $1,000 no more than $5,000 or both. This bill passed out of Senate Agricultural Committee unanimously and off the floor unanimously in the Senate, and I commend it to you and would be glad to answer any questions. It's good to be before House Judiciary. I haven't been here in a while.
Okay. Questions by the committee for the author? Representative Byrd?
Yes. Is an actual marijuana in the candy, or is it just a flavor, just like any other kind of lollipop?
No, it has the THC, which is what gives marijuana its effect. But it is a marijuana flavored candy.
Follow up, please.
Yes.
So the candy is actually made of some substance of marijuana.
Yes.
Okay. And follow-up question, please. How is it that it's being sold then in candies, on the shelves, if it actually has?
That's not a question I can answer. Why it's being sold.
Thank you.
That's a good question, though.
Questions of Representative Levitas?
I have a couple of questions. Thank you for being here, Senator.
Mm-hmm.
The first one is, I'm understanding this is a 1 to 5 felony?
Yes, sir, for the second.
For the second, and the first is a misdemeanor?
Mm-hmm.
How does that compare, to your knowledge, with a second possession for marijuana?
I do not know.
Okay. I don't know offhand, but I suspect it may not be quite that much. I may be wrong. I may be wrong. It's been years since I've looked at one of these cases. My second question is, we passed a bill out of the House, that prohibited the sale of what the author referred to as chronic candy to children.
Yeah.
Since that's already passed, do you see any harm in letting that become law, see where it goes, and maybe coming back and revisiting this?
The bills are very similar, and I don't know. To answer your question, I don't see any harm in letting that one move forward, nor do I see any harm in letting this one move forward. I'd like, and I think the community that's been aware and educated over the last several years would like to see a bill pass. And I think if you pass this one out, you'd have the chances are that one will pass, whether it be out of the Senate or out of the House.
Thank you.
Any other questions for the author? Mr. Lunsford.
I'm sorry, I must have too much caffeine today. I've got a question, just philosophically.
Sure.
Page 1 of the bill, Senator, looks like Georgia code. Page 2 of the bill looks like a study committee or Senate resolution. And I was going to ask, the council, is it typical that we put other states' statistics in the Georgia code and codify it? In other words, where we say, we begin at page 1 on line 25, we talk about the monitoring future study and the percentage of 8th graders and every 10th graders and 12th graders, and then we move through the bill and the rest of it's almost like a resolution. Is that normal?
Well, it's up to you all to determine where legislative findings go, whether or not they're codified. This bill is drafted in a manner in which you would codify the legislative findings. But there are a number of circumstances where you'll see legislative findings, like in a section 1 of the bill, and it's not codified, and in section 2 of the bill
Right.
is
This is the codified portion.
The codified portion, and then in the editorial section of the code, when it's published, the findings would be there, but they wouldn't be in the text as it is here. I can't say that it's completely uncommon. It goes both ways in terms of codifying findings and not codifying findings.
Just curious. Go ahead.
Go right ahead.
Chairman. On page 1, line 21, you say person.
I'm not looking at the numbered text.
34, 1154.
Okay, I have it now.
We have a description of who a person is, and the question is, it says person means any natural person, comma, individual. Is not an individual already a natural person?
Representative Lunsford, this is language that was provided to me by legal counsel, and you're not asking me that question.
Absolutely.
Okay, all right.
Counsel.
Okay.
Could we not strike the word natural person or strike the word individual because they're not synonymous with each other?
Before we get into possible amendments, can we just go through, there's some other questions. Is that all right?
I have one more question.
All right, go ahead.
Question. Senator, I do have a question for
Sure.
you. You're aware of it or not. Many of your health food stores sell a product called hemp oil. And hemp oil is a derivative from hemp plants, and it's used for many things, for flavorings, for oil, for lamps, for everything. But you know, it contains THC in small quantities.
Sure.
So, if we move forward with this, advertise having the flavor of marijuana or hemp, how could they sell hemp oil without having the flavor of hemp?
Let me say this, Representative Lunsford. I am open to.
I'm just curious.
No, I understand what you're saying, and I appreciate your curiosity, and that's why, my intent is to go after the marijuana flavored candy.
Sure.
Okay, and and I do know of hemp-flavored oil, soap, and other products that are sold. So I'm not adverse to, an amendment that would be.
I'm not trying to destroy your bill, Senator. I'm just curious, how do we take a segment of the industry that's already making a product, has for years, for a completely natural, legitimate, legal purpose,
Sure.
and we say that hemp oil can never say that it has hemp, or smells like hemp, or tastes like hemp?
No, I understand, and I no way.
I don't know what kind of oil we call it.
And I'm not interpreting your questions in any way, in any other way.
Thank you. Representative Abrams, did you have a question?
A parliamentary question for either the chairman or for Mr. Travis. Going back to Mr. Levitas' question, since we passed a bill that creates a misdemeanor for a similar offense, which would take precedence if both were to pass the House and the Senate and be signed into law?
They would both become law, and I assume that the misdemeanor for that, my recollection is that was a misdemeanor for selling it to children, if I remember correctly. That would be a separate offense from this. This is selling it to anyone, is my understanding of this particular.
That's right.
Thank you. Mr. Chairman Knox, did you have a question?
I guess I'm trying to get at with
where we're trying to go with this, actually. You know, one of the concerns I have about it, and I appreciate your efforts, Senator. One of the concerns I have about it is that it seems like it's about as easy to get marijuana itself as it's going to be to buy marijuana-flavored candy. I mean, I don't notice anybody having I don't notice anybody in the state of Georgia having trouble getting marijuana. It's a very well marketed and sold. It's $1 million a year. I mean, millions of dollars being made on marijuana. You know, I mean, there's hardly anybody that doesn't know somebody that knows somebody that can get you some marijuana if you want it bad enough. And so that being the case, I'm not sure how selling marijuana-flavored candy is going to appeal to somebody when they can, if they really want a marijuana flavor, you can get the real deal instead of wasting your money on the candy. Most of the people that are trying to buy marijuana are trying to save all their money to buy the marijuana. They're not going to waste it on buying something that tastes like it.
Well, this is the only way that I can respond, and I probably should have said this when I began my comments. You know, one of the things in my district, and I'm sure in every district that is represented here, the issue of drugs is a very, very serious one. And it is, to my way of thinking, it may be the most serious problem that we face. And in these products, Chronic Candy and the other brand names that you can go on to the webs and see at any, you know, right now if you'd like, Chronic Candy, etc. They're marketed to children. They're marketed by hip-hop stars and others who want to sell this. They're sold $2-3 a pop, no pun intended. And it's marketed with campaigns. They have Chronic Candy and Dope Candy vans going through the community marketing this. And I think one of the last things we need as a civil society is to encourage, directly or indirectly, our children to partake in anything that would encourage them or give the impression that dope was something that we wanted them to use. So I think it's a serious situation, a serious issue, and you know, I think moving this one forward as you moved Representative Manning's forward, and then I know Chairman Bullock has a similar piece of legislation that he will talk about in a few minutes. I think passing this legislation forward just increases the chance of one of them passing and becoming law and protecting children and protecting our communities. Now, whatever, you know, and I'm, you know, if there are changes that this committee sees fit, I'd be glad to consider them, and most likely would be very supportive.
Further inquiry, Mr. Chairman? Yes, further. Go ahead. Yeah, and I'm not trying to debate this.
Sure.
But this whole drug, you know, the war on drugs in Georgia, like in most countries, in most parts of the country, is not really a war on drugs. It's a war on people who use drugs or people who want to use drugs. And we ought to be careful about that, because we're not really putting any drugs in jail. We're putting people in jail who use certain kinds of things that we think they shouldn't use. We used to do that with alcohol, and that turned out that experiment didn't work very well. And my concern with any of this, and not just this piece of legislation, but a lot of the legislation we see coming through this committee with respect to trying to limit or trying to criminalize behavior with respect to the use of drugs. And now in this case, it's not even a drug, it's just something that everybody knows is not a drug, but it tastes like a drug, or it'd be sort of, you know, you could sell a little bag of weed, I guess it would look like marijuana, and if you advertise it, here's, you know, marijuana weed to put on your wall or whatever, I guess you could do that and sell it in little green packages, little packages of green weeds, and, you know, you could make that unlawful based on the same premise. And what concerns me about it is that, you know, if we keep further criminalizing further behaviors that are now not just using drugs, but using something that it resembles a drug, but that we know is not a drug, and it's not sold as a drug. It's just sold as something that looks or tastes or smells like a drug. You know, that's not really in and of itself anything criminal.
I think you can make the case for the use of drugs, that it has some deleterious effect on you. Clearly, when you do it, it has some deleterious effect. I think what you have at best here is the possibility that this may lead to some other behavior if this is allowed to happen. And what I wonder about is whether or not we should spend the money and the time on something that's not a drug. When we're trying to solve the drug problem, we should be spending that money on trying to actually solve the drug problem if it can be solved through the criminal process or the criminal justice process, and I'm not satisfied at all that it can. We've been at it for 50 years, and the more we do, the worse it gets. And so I guess my question is, do you really want the state to spend money and resources trying to keep people from doing something that's not actually using something that's not actually a drug, that they know is not actually a drug, and that's not sold to be a drug, but sold to be something that tastes, smells, looks, feels like a drug?
Let me just say one. That
was a long question.
It was long, but it was a terrific question, and I appreciate it. One, I don't necessarily agree that it's not a drug. Two, I have been throughout my career, before I came to the legislature, as concerned, as to that contradiction between the war on drugs and war on people, and I've seen it play out very seriously over the last 6 or 7 months in my district. So it's something that I'm entirely sympathetic to. But I do think that this bill does go after a situation in our districts and our convenience stores, head shops, wherever. That's very serious. And I guess maybe that's where I disagree. I think it's a serious situation. I'm loath to do something that wouldn't be helpful, but I think this bill has benefit.
I don't have anything further. Thank you, Mr. Chairman.
All right, I think there was one other question. Mr. Levitas.
Here's my question. I have looked it up since then. This is my concern again. So you'll understand, I voted for the bill that passed out on the House side, so I certainly share your concern about this. What I'm worried about is a concern that some of my colleagues have expressed about other bills is if we are going to punish possession of the chronic candy worse potentially than we're punishing, or more harshly than we're punishing possession of the drug itself, that concerns me. I don't know whether the answer is to step up the punishment for possession of marijuana or to, as I said, maybe see what happens with the bill that's already passed out. But if you possess less than an ounce of marijuana, that's going to be a misdemeanor no matter how many times you repeat it. And I know there's some reluctance around here to change repeat offenses into felonies, though that's certainly not something I am shy about. But that's my concern, and I guess my other concern is this, is the language that Representative Lunsford talked about. There's a lot of language in there that seems like it's, I don't know if study committee is the right word. I'm just not sure that it gets to what we're doing. And this is something, one of the sections I noticed was in subparagraph 8, there's a line on page 2 at line 18, the sale of marijuana-flavored candy, including lollipops and gumdrops, which claim, quote, every lick is like taking a hit, close quote, is a marketing ploy that perpetuates an unhealthy culture, should not be permitted. I don't know that any of that stuff is not good language to have. I'm just not sure about whether it needs to be codified. And I guess where I'm headed is I think this is a very, very good idea. We want to discourage drug use any way we can. We certainly want to have punishments, but I think that, at least from my perspective, I would want some more time to study this particular measure, because I'm afraid what we may wind up with is based on some of the comments I've heard today, is we might wind up without having any consideration.
And as I said, Mr. Levitas, I understand your concerns, and there may be some that I share, and I'd be willing. I mean, it seems to me that and I know House Judiciary is never reluctant to make changes to a bill that comes before it. And if you have any changes you'd like to suggest at this point, I'd love to hear them.
Call on Mr. Franklin. Do you have a question or something?
Yes, Mr. Chairman, I appreciate that. I think in light of a lot of the questions that have been raised, and also since particularly including Representative Byrd's question about flavor, since our nice friends over on North Avenue have a product made from the coca leaf. Though it does not contain cocaine, cocaine also comes from that same leaf. I think out of an abundance of caution, Mr. Chairman, I move that we table this bill.
All right, there's been a motion to table. That's in order. Is there a second to the motion? Second. There is a motion and second to table. Is there any further discussion of that motion? If not, discussion?
Yes.
All right, go ahead. Not really.
With all due respect to Mr. Franklin and some of my colleagues that appear to, I don't believe that this in no wise goes toward our friends over on near Tech campus that have do considerable business in the state of Georgia. I believe that to argue such would indicate that they would not have 1,000 attorneys down here letting you know that that is the case. And if it is your disposition to stop the legislation because you believe it has that implication, I think that we can remedy that. However, I would like to say not only the issue that came up about hemp oil, and I was intrigued about that, and I could understand that. But the definition of marijuana flavored candy has no possibility of including the substance of which you spoke, Mr. My distinguished friend from wherever you're from.
All right.
But I'm simply stating that this is a gateway, and that I have had some personal experience to see that it does open the door for persons to enter into a culture. And if the author, if it does no damage to the author, to take out the legislative finding, if that is your biggest concern, Mr. Franklin, because I don't believe that would, I don't know this, and I have not talked with the author about this, but I would not like to see this legislation proceed a few more years, because what it has done, maybe not in your neck of the woods, but in my neck of the woods, what it has done is created an atmosphere used by even musicians to perpetuate a culture that is destructive, and it really destroys the hopes and dreams of quite a few young people, because it unknowingly, unwittingly snares them into a drug culture that is glamorized. And I would simply say that if you are concerned about that, and I have to ask the author, I don't think it does anything to the author's bill. If
all right, we've got a motion to table and a second, so I'm allowing you to speak to the motion, but we're not going to start amending. So,
may I respond, Mr. Chair?
Just one moment, please. You done?
I am done, to the extent that I would ask my colleague from Mr. Franklin to consider modifying his motion to the extent that it not derail the effort to stop a culture that preys upon my community and your community.
Mr. Ford, I'll allow you to respond.
Yeah, thank you, Mr. Chair. I appreciate that consideration, and I appreciate the committee's time. This bill is very similar to a bill that I think just about everybody on this committee voted for, either in committee or on the floor. And I know that, that this committee is, as I've sat here for about an hour, is not reluctant to make amendments to change bills in its breast. So, I would hope you would do that as opposed to killing the bill. Thank you, Mr. Chair.
All right, there's a motion to table. It's been seconded. All those in favor of the motion, raise your right hand. All those opposed? What's the count? 5-4 to what? To table. Motion, the bill is tabled. Thank you very much, Mr. Ford. I would point out that this committee has passed a bill which prohibits the sale of these candies to children earlier this session. All right, the next bill that we're going to take up is the list. Senator Bullock, let's take up agricultural and forest products, limited liability first.
Thank you, Mr. Chairman. I have provided y'all with a committee sub. I hope that all of you have that, which would be LC 254964S. And I can, before I try to explain the whole bill, the first thing I'd like to do is just explain what the difference is in this language. Only changes two things from the original bill. On page 2, on line 24 and 25, we have added in after agritourism professional has been, we added shown by clear and convincing evidence, and then we changed the date on it. Changed the date on it on page 3, line 29, to where it would become effective on January 1st of 2008, just in essence of giving the industry an opportunity to adjust to the requirements under what this legislation would require. Now, having said that, I'll try to explain the bill and the need for this piece of legislation. When we talk about agriculture and we talk about the forest industry, it's not your normal everyday industry where you have a controlled environment and control over everything that's there. And in the efforts to try to promote agriculture and tourism within the state of Georgia, agritourism is becoming a very participating business, especially in the area of school children. So what we're trying to do here is to give the opportunity for those businesses that want to participate in this activity, that they would have certain protection from the standpoint of liability and the tort laws of the state of Georgia. And what was originally presented in committee on this bill on the Senate side, and we have worked with the Trial Lawyer Association and to try to address some concerns, and it's an entirely different bill than what was originally presented, and I'm not saying that everybody's totally happy. We in agriculture and in tourism aren't completely happy, and I would say that maybe some segments of the legal segment of our society may not be totally happy, so it must be a pretty good bill when we've got something that nobody likes. I'd be glad to try to answer any particular questions about this legislation, but I know y'all have been here a long time, and I appreciate Chairman Knox in a subcommittee scheduling this for a hearing, but in essence of time, he was not able to get to it a couple of weeks ago. So,
all right, questions for the author of the bill? 4964S, I think, LC 254964S. All right, any questions for the author? There are some other people signed up to speak on this bill. Yes, ma'am.
I just want to be sure agritourism is, for instance, a farm that has changed it. They grow corn and then they make a maize. Is that agritourism?
Yes, that would be one segment of it. A lot of innovative ideas have come about in agriculture lately of trying to find a way to promote agriculture and bring in tourists and generate actually revenue. I mean, I'm not going to cut that out, because if it's not going to be beneficial, then you don't do it, because you are exposing yourself. But we do have a lot of school children that go out, and we have these pick-your-own strawberry patches, which is in the Georgia Code. Pick-your-own operations do have some exemptions, but at the same time, school children. And it's a great opportunity for school children to see that everything that they eat doesn't necessarily come from the Kroger's or Publix or whatever food store. But at the same time, we have to realize that we are in an environment in agriculture and forest industry that we can't totally control everything that's there. I mean, and in here, I mean, it says, and I really had a problem with this, but we conceded and said, okay, but it shows where it says you should have known. Well, yes, I should have known that on my farm there was a possibility of a rattlesnake being out there in that corn maze, because that's the habitat for that animal. And but at the same time, we're trying to provide an opportunity, and we try to warn, and so this puts a lot of posting requirements on these operations, that they have to post it to where those participants would be aware of it. And it's that example you gave is a very simplified example of what some of the more in-depth type operations have. I have, over the years, not at any charge, entertained a lot of school children and all out to see my farming operation. But there's a lot more interest today. There's a lot of interest from adults that come from all parts of this country that want to see what agriculture looks like out on the farm. And so I think it's a great way to continue to keep the public informed on what takes place in agriculture, and at the same time give an opportunity for that farm, if they want to do it for pay, to be able to generate some additional revenue. And that this is the only people this is involved with, is that if it's a business dealing with agritourism.
Thank you very much. Any other questions for the author of the bill? All right, I don't see any. We have some other people signed up to speak. Jeffrey Harvey with Georgia Farm Bureau. You can stay right there if you want to.
Yes, sir. Thank you, Mr. Chairman. I'll be very brief. Members of the committee, I'm Jeffrey Harvey with the Georgia Farm Bureau. I appreciate the opportunity to address you today. We come in support of this bill, and as the chairman said, I'm going to echo a lot of his comments. This just adds...
Please don't repeat his comment.
I'll try not to.
Get up and go to the back.
This offers us the opportunity to add more value to the farm, and also, as the chairman said, educate children and the public as to where their food and fiber and soon-to-be fuel comes from. And like I said earlier, this is a priority to us, and we just appreciate your favorable consideration.
Thank you. Questions for this witness? I saw Ms. Abrams first, Chairman.
Thank you. I will preface this by saying I supported, I think, an identical version or a very similar version of this bill in Ways and Means, and looking not at the substitute but at the bill as it came out of the Senate. My only concern here is that we create a lower standard. Well, the substitute attempts to create a heightened standard for liability when your primary audience is children. My concern is that when you require clear and convincing evidence, as opposed to simply requiring that they knew or should have known, you create a higher standard, a higher burden for a child. I mean, essentially, you're making it harder for a child who is injured by engaging in this activity to recover under the statute. I'm completely sympathetic to and supportive of the underlying notion, but can you talk to me about why you all require clear and convincing evidence when that's not the general standard that's used, and it's not the standard that passed out of the Senate?
I'm not an attorney, so I'm going to tell you I'm not an expert in that issue, but what I do know is that from the people we have talked to is the version of the bill that passed earlier basically gives us no protections other than requiring us to put up a sign. And the version that we're working with now will actually limit some of our liability. I don't know if the chairman wants to ring in on to answer your question or not, but that's where we're at on that.
All right. Chairman Knox.
I know you said you're not an attorney, so I'm just going to ask this question. Maybe the senator can answer it for us. But I guess what I'm trying to get at is what protections are there in here that aren't in the law in general with respect to tort liability and the duty of care that's owed to a person that you ask to come to any kind of a business, whether it's an amusement park or a swimming pool or a playground or a campground or whatever it happens to be. Is there something peculiar to the agribusiness, agritourism business that requires this law? And what's in this law then that addresses whatever that peculiarity is of the agritourism business? I don't know, maybe I see legislative counsel looking around like she doesn't know that I'm looking at her, but
I thought you were looking past me.
I thought you were looking for the closest door, but I don't know if you want to weigh in on this or not, but I'm sort of struggling with this. I'm trying to see what's in here that isn't in the current, that isn't already in law, and why it would be necessary. What would be peculiar about the agritourism business that would require a change in the law with respect to the duty of care? That I think is what we're talking about in here, isn't it? Or am I mistaken something?
I think you're right. I mean, I have to say that I didn't draft the bill, and I certainly didn't serve on the Senate side, so I'm not familiar with the reasoning behind the bill. Maybe the sponsor of the bill can help with that.
Mr. Chairman, if I may.
Yes.
And let me say that your legal counsel representative here looks a lot better than our legal counsel that did the drafting, so we'll trade with you if that would help any. And maybe
we think she's smarter, too.
Well, I'm not going to get into that part. And Chairman Knox, I promise you, I'm not an attorney. I've never tried to represent myself as an attorney.
I thought you'd stayed at the Holiday Inn, though.
I have, and I had a good night's sleep. The intent of this legislation is that as we move forward in other areas in agriculture, that with this specific industry developing, that we wanted to have it identified in the Georgia Code, and we wanted it to where we could identify what the requirements would be, where we have the signage in it, as well as giving some protection to those entities above the general law, because we are, to some degree, when you say you go to an amusement park, you know it's a Ferris wheel, you know it's I don't even know what they have at those things anymore, I'm a little old for that. But here, we're in an agricultural setting, and the potential dangers, one of the highest occupation as far as employee injuries are concerned are in agriculture. And this probably ain't real wood, but on my farming operation, I haven't had even a finger mashed in over 10 years. I mean, I'm fortunate. I've got good employees. But that doesn't mean that when you bring a lot of people that aren't aware, and you can do all the signage you want, but there are just those things that maybe are known or should have been known, but we don't see them because of the fact that it's a normal activity, that we have wildlife, we have unleveled ground, because we're not in a parking lot, we're not there, we're out in an agricultural setting or forestry type setting, and that's the intent of what we're trying to do. Not to give them the original draft had the same language that excluded the emergency room doctors. Now, that didn't last very long when we first started debating this bill in committee, and we have made a lot of concession from that standpoint to where we are today to try to come up with a version that addresses what our attempt is, and at the same time we're not being ridiculous in what we're asking for.
Follow up? Sure.
I guess one of the things. Well, let me ask you this first. If I'm operating and I'm in favor of agritourism, I think I like to go and see what's going on the farm. And we've got that facility down on 75. What's the Agorama, where which is a really great educational thing there. But that's going to be different than what you're talking about here, where I've got an actual working farm. And somebody brings in 8 school buses full of little rugrats and turns them loose in the place, and they're swarming over combines and tractors in the barn, and examining pitchforks and whatever else is around there. I see that as that could be a real problem, and I think we need to be careful that we don't create a false sense of security because we have this law on the books, because I wouldn't want to be in the agritourism business without one hell of an insurance policy to protect me, because I can easily see where you could get overwhelmed if you're not in this tourism business, you're in the farm business. You're going to find out, I think a lot of folks are going to find out that this takes a lot more expertise to operate this than maybe they're thinking about with this particular thing. Last thing I'm going to ask is there anything in this bill that keeps me from sticking a Ferris wheel or a merry-go-round or a bucking horse out in the field for kids to get on when they come to the farm to see how, kids don't get on cows, because here's what will happen, and when you turn on the machine and, throws one over the fence. Is there anything to keep me from having those kind of things like attractions at the farm in order to encourage people to come to my farm to see my corn instead of the corn in the farm next door? You follow me?
Yes, sir.
Okay.
There's a definition of agritourism, which is on page 1.
Yes, sir.
Line 22.
Are we on?
It says
2964S still?
Yes.
Okay.
Activity carried on real property that is a farm or ranch that allows members of the public for recreation, entertainment, or educational purposes to use, view, enjoy agricultural property, machinery, resources, goods, domesticated or wild animals, history, or culture. An activity is an agritourism activity whether or not the participant paid to participate in such activity. This is, I don't think a Ferris wheel or whatever you wanted to describe would be considered covered under this.
I'm not sure it prohibits it. I don't think that definition prohibits an agritourism business from having an attraction other than simply the implements that we usually use on a farm. Because I understand that they're trying to make a distinction whether or not you're paid for it or not. It's not the issue. I understand that. Because I could do it for free and still have an old Ferris wheel that I got from some amusement park that went out of business. And I don't think there's anything in this definition that would keep me from having a Ferris wheel operating on that property.
All right. Other questions? We're trying to direct questions to Mr. Harvey. Any further questions for Mr. Harvey? All right. We have Mr. Brian Toller from the Georgia Agribusiness Council. Good afternoon.
Good afternoon. Thank you, Mr. Chairman, members of the committee. I'll be brief. My name is Brian Toller with Georgia Agribusiness Council. We have members all across the state, even here in Metro Atlanta and certainly down in Thomas County where Senator Bullock's from. Biofuels and agritourism are two of the growing areas for agriculture. We need to do everything we can to encourage those, and I think this General Assembly has done a lot just in this session to do that. I'll address just real quick the question with regard to Ferris wheels, because I believe we have a piece of legislation that's on the move this year by Richard Royal that is going to address the issue of agritourism activities that will not violate CUVA parameters for land that's enrolled in the CUVA program. A Ferris wheel certainly would violate that, and every farm operation wants to act within the confines of CUVA because they want to have that valuation assessment for their benefit. So that's where I believe we can address the Ferris wheel issue. On a second note, the question about being able to access corn mazes. Not only that, we have pumpkin farms, we have apples and peaches, and all these commodities that we produce in this great state. But so very few people get a chance to see them. We have a program at the Department of Agriculture called Georgia Grown. I'd love people to go see what's actually grown in Georgia. not something that has a label or sticker stuck on the side, but actually go see it, see how it's made, see how it's produced. And on line 17 of page 1 of your bill, you'll see the very last sentence there. It is therefore the intent of the General Assembly to encourage agritourism activities by limiting the civil liability of farmers involved in such activities. We'd love to see that. This bill would do that. It'll provide some protections. It'll provide some signage. It'll provide opportunities. It'll provide rural economic development so that they can take these farming operations, not Ferris wheels and not entertainment complexes, farming operations, and bring children, bring adults to come see longleaf pines, to watch birds, things that we can't do right here in the metro Atlanta area, we can do all over the state. Give them that access by limiting the liability for the owners of that land, the farmers of that land, to let people come out on that property. That's what we hope that this bill will do for you. That's what we certainly would encourage you to support this legislation, the committee sub that you have in front of you, because we need this so that agriculture can have a chance to show off what it does so well, what it's always done so well, to make it the #1 economy in this state. Agriculture drives the state. Let's let tourism continue to build and share that relationship with agriculture. With that, Mr. Chairman, I will yield to any questions you may have.
Any questions for Mr. Tolar? Yes, ma'am. Ms. Charlize Bird.
Is it not true it's personal responsibility when you go to these kinds of places?
We should all access more personal responsibility in where we go, but you're exactly right. So that's going to come into play, how we behave anytime we're out in public and on somebody else's property, and we want to limit the liability of those property owners when people do come on that property.
Thank you.
Good question.
All right, I don't see any other questions. Thank you, Mr.
Thank you,
Tolar.
Chairman.
We also had Mr. Bill Clark on to speak to this bill.
Thank you, Mr. Chairman. Ladies and gentlemen of the committee, I'm Bill Clark on behalf of the Georgia Trial Lawyers Association. We do not oppose Senate Bill 272. We have worked with Senator Bullock to help his bill improve. It originally was introduced as a pure gross negligence bill. The only way you could hold anyone accountable would be by showing gross negligence. We changed the bill essentially to mirror the equine or horse activities law that is on the books in Georgia law right now. And what this bill does now in the version that passed the Senate, as opposed to the committee substitute, is it says they're going to be immune unless you fall into one of the exceptions. And then the exceptions basically require the property owner to exercise ordinary care for the customers, the paying customers, and remind you this is not a charitable operation, this is for fee, to require them to provide safe premises, or at least to make those coming on the premises aware of hazards. Senator Bullock talked about, he was not necessarily so familiar with amusement parks, but the purpose of requiring people at amusement parks to keep their premises safe is because some people coming on there don't know what the inherent risks in an amusement park are. This bill says farmers can know about the inherent danger, and when city boys like me, or worse, my children and yours, come onto their property, they have virtually no duty to those persons coming onto the property. This bill is a policy choice. Do we favor promoting agritourism at the risk of our children, who will largely be the invitees, the customers coming onto the farm property? There's a right way to balance that. The House Ways and Means Committee took up an almost identical bill, fixed it so that it mirrors largely what passed out of the Senate, that does strike a good balance of both encouraging agritourism through lessened civil liability, but also still requiring an appropriate duty of care to the customers. The Senate committee also did that with the version that ultimately passed the Senate and is before you. We would object to the committee substitute in that it adds the heightened burden of proof on a plaintiff of clear and convincing evidence, a standard that is only found in the torts code in a couple of 2 or 3 places, and most notably in the emergency room area. And while we certainly, as many of you recall, weren't supporters of that level of protection for emergency room practitioners, at least those folks were providing a vital, by definition, life-saving service. Contrast that with providing access to learning how crops grow. I'm not sure that they, on an interest evaluation basis are equal with one another. So we would ask you to not support the committee substitute that's before you, or if you were to do so, to strike out the requirement of clear and convincing evidence that is inserted in the bill. We certainly have no objection to the extension of the effective date. I think Senator Bullock raises a good point there. This does require the posting of certain signage, and folks need an appropriate amount of time to be able to do that. So I'll conclude with those comments. I think the Senate, as passed version, struck a good balance between those interests I've talked about, and we would ask you to support that rather than the committee substitute. And I'm glad to answer any questions, Mr. Chairman.
I've got a question for you, so let me ask this one. Are you suggesting replacing as shown by clear and convincing evidence with any language?
No, simply...
I'm sorry, where are we?
Line 24, page 2 on the substitute.
On 4964?
I don't think we have the original Senate bill in our packs.
You do.
We do? Sure.
To make the committee substitute mirror the as passed the Senate version, you could strike on line 24 of page 2 everything after the word professional. Strike line 25 except for the colon. So the sentence would read that nothing in subsection A of the code section shall prevent or limit the liability of an agritourism professional if that agritourism professional, colon, 1, 2, 3, 4. And then insert the appropriate effective date as recommended by Chairman Bullock.
So there's no need to put another, like a preponderance of the evidence or any other standard of proof.
The standard burden of proof in civil actions is the preponderance of the evidence unless indicated otherwise by the legislation.
All right. Otherwise, we could simply adopt SB 272 CSFA 2 and have the same. No, we could not.
The easier way to do it would be to do the committee sub, amending it as I've suggested would work, and then you could pass the committee sub as is with that stricken language that I've suggested.
Give me that again, so I'm absolutely sure I've got it. We're going to start striking with a period at the word...
No, sir.
Line 24.
Page 2, line 24, following the second use of the word professional on that line, don't insert anything, just strike the rest of that phrase and through line 25 up to the colon.
Okay.
So essentially you'd be putting a colon after that second professional on line 24.
All right. I've got one thing I want you to talk to. Just, I remember in this state when we were to a point where almost nobody was letting people ride horseback because of liability issues. And I remember that we passed a law that allowed people to ride horseback, which I think has had a salutary effect, and I now know that there are a large number of people that are providing horseback riding for tourist purposes. Are you telling us that this law is, as you're proposing it, is basically the same law that allowed horseback riding to be reinvented in this state?
That's correct, Mr. Chairman. What we did is we took the language that is in that code section, I've got a copy of it if you'd like to see it, and tracked largely, almost verbatim, the equine activities statute that was passed when the chairman of this committee was over in the other body, way back in 1992, I believe. And yes, and in fact, not only was
At that time he was just a pony.
In fact, the Georgia Trial Lawyers Association did not oppose the passage of that bill either because it was an appropriate balancing of both duty and interest for the equine industry.
Okay. You want me to keep going?
Yep.
Mr. Knox.
Since you are, I'm thinking you are an attorney.
Yes, sir.
Clark, in that case, maybe
I'm a recovering one. Yes, sir.
recovering attorney. All right, let me ask you if you can help me with this then. I'm reading at line 21 on page 1, as used in this article, the term agritourism means any activity. Any activity. Doesn't say it's any farm activity or any agricultural activity. It says any activity carried out on real property. And then it goes on to say, which allows members to enjoy, on line 24, I guess that is, or enjoy agricultural property. Now, agricultural property could be the real estate itself, or it could be the barn, or it could be the cows in the field, or whatever it could be. But I don't see anything in this definition that would prohibit. And I hate to keep using this example or metaphor, but I don't see anything in this that would keep me from having a Ferris wheel or a merry-go-round with all kinds of cows and horses and goats and chickens all chasing each other around. The kids can ride on it, and you can run it 462 miles an hour in a circle if you want to. I don't see anything in here that says that this prohibits anybody from doing something other than agricultural activities for the benefit of the people that are coming to see it.
I would agree that there is no clearly limiting language as you are suggesting there might be. I also would respond to the gentleman before who referenced another bill that defines agritourism within the Conservation Code, but even the Conservation Code, which provides an ad valorem tax break, allows up to 50% of that property to be used for non-conservation or crop-related purposes. So there's nothing in that other bill that prohibits the Ferris wheel example, and we share that interpretation of this definition that you do.
I guess what I'm trying to get at is that even in the instance of the conservation use, if I have 100 acres and 50 of them are conservation use, I could have a fence on that I'm running rides on the other side of the fence to see my conservation use area. And there's nothing to prohibit that even under that code section. So the way I look at this, I don't see anything in here that would prohibit somebody from doing something other than showing me how tomatoes are grown.
If I could, and Senator Bullock certainly is better positioned to respond to that than I am, but I would say that I think the bill, in the latter part of the bill, appropriately balances the risk of having a broad definition by making sure that they are required to exercise ordinary care to a certain degree for their customers or invitees. So,
regardless of what they're doing.
Regardless of what they're doing. Riding a Ferris wheel or a cow.
Any follow-up?
Or a horse.
Any follow-up?
No, I'm done.
Ms. Abrams.
After time, I'd like to recognize for motion.
All right, is that on a motion to amend?
Yes.
All right, I'll hold that just a moment. Oh, my other questions went away. Mr.
Just briefly, on the changes that you suggested, you said with that language in there, that's exactly how it passed out of the Senate. With the language that you struck and then added in there, that's how it passed out of the Senate.
That's what I understand Senator Bullock and his staff have indicated. That was one of the only two changes made between the as-passed version and the committee substitute before you today. It was the change in that language and the addition of the effective date.
Thank you.
All right, any other questions? If not, I'll entertain the motion that Ms. Abrams suggested a moment ago. Mr. Chairman. Yes.
Might I address the committee before you take a motion? Sure.
Thank you, Mr. Chairman.
I bring this bill before you today, and I know you're taking testimony from other people. It's a hearing, and that's the process that we live with. And all due respect to the previous speaker, but it's not his bill. It's our bill that we presented, and when we looked at it, and the reason we made these changes, we felt very confident that this would improve this piece of legislation. And I ask you to consider it as I have presented with this substitute, and that it's still a good piece of legislation. It does not give undue protection. It gives just good protection to people that are trying to promote agritourism.
Thank you. You have a motion. Let's go ahead and make the motion.
I would move to strike, so for LC 254964S and line 24, after the second professional, strike the words has been shown by clear and convincing evidence to have, and then to renumber the remaining lines and sections.
Is there any reason to renumber them?
No, there isn't, so I'm going to stop talking now.
All right. There is a motion and a second, as I understand it. Is there any further discussion of the motion? No further discussion. All those in favor of the motion, raise your right hand. All right. The motion appears to carry. All right. Are there any further amendments to this piece of legislation? What's the committee's will regarding this piece of legislation? Mr. Knox. Yes.
Mr. Chairman, I move to amend the bill further by changing line 22 to the following text that on beginning with agritourism means any activity, and after activity inserting therein involving agricultural activities carried out on real property and so on. So I'm suggesting we amend it by inserting the words involving agricultural activities after the word activity in line 22 and the word carried.
All right. Is there a second for that motion? Is there a second?
Second.
Second of the motion. All right. There's a motion. How does the author feel about that motion?
I don't have a problem with that. I mean, I think it just clarifies what kind of activity you have.
All right, so let me make sure I have that then. While including an agritourism activity...
Agritourism means any activity involving agricultural activities carried out and so on.
Means any activity regarding agricultural activities.
Right. Involving agricultural activities.
Any activity involving agricultural activities.
Could you just say it means any agriculture activity?
Okay, yes, that's fine.
Figure it out.
All right, Joe, you got that?
Well, my suggestion was that you just change it to agritourism means any agricultural activity.
Right.
Instead of...
That's good.
All right. That's been accepted by the author, so that will be an accepted amendment. All right, what's the will of the committee regarding this piece of legislation? Is there a second? There's a second. All those in favor, raise your right hand. Opposed?
Sub, yes.
As by committee, sub as amended. Are those opposed? None. Do pass.
Thank you, Mr. Chairman.
Y'all didn't do 295?
No, sir.
All right. I'm sorry. Who's handling this on the floor for you?
Representative McCall.
All right, Senate Bill, and I'm sorry, Senator, but I was up on a little bill that you and I are working on.
I got the message.
I'm not sure it works. Senate Bill 295.
Thank you, Mr. Chairman. Senate Bill 295, it's a bill that, as we discussed a little bit when Senator Fort was bringing up the bill about flavored candy, and the question was asked about, does it have an effect? Do we have statistics? This is something that, as we look at newfound products, newfound dangers, that and what I'm going to operate off of would be SB 295 CS. No, let me get it right. LC 254927, and there is a change there that was requested. It's on page 1. Diane, don't you have, everybody have this? This was requested, this change. It's on page 1, line 22, 3, 4, and 5, and it's where we put in some language at the request of Emory University from a standpoint of giving some protection to people that do research on different things, whether it's for medical or pharmaceutical research. And this was language they had asked to be included in that, to give them protection.
Do we have that? Oh, it's in the sub. It's the sub.
That is
Okay, all right.
4927S. Yes, that's what's included down on line 22, 3, 4, 5. You probably never have heard of the plant Salvia divinorum. You all probably have heard of salvia because you have a lot of salvia planted in your yard. That's a very beautiful ornamental. But what we're dealing with here is a plant that is native to the mountainous area of Mexico. And it has a chemical in that plant that gives a very quick hallucinogenic high. Those that have used it will comment that it gives you a higher high than LSD. Now, it does not last long. It normally lasts from 1 to 5 minutes. But it is becoming a real problem. And I saw a television report, an investigative report about this, and started doing a lot of checking. And I have talked to DAs across the state. They've become very concerned. I've met with the director of the GBI and his crime lab people to see if what I was trying to accomplish here was something that could be defended in a court of law. It is only a misdemeanor charge. But what this bill does is it creates where it's a misdemeanor to produce, manufacture, distribute, possess, or possess with intent to produce, manufacture, or distribute the chemical Salvarian A, which is found in this particular plant that is native to the mountainous area of Mexico. And as I did my research, and I'm not a computer person. I talked to my youngest daughter that's in graduate school. She does all these things on the internet, and she was very familiar with YouTube. I had never been on the website YouTube, but you can go to that website and type in salvia. And when you look at it, there are over 900 postings. And these are videos. Now, I didn't look at all 900, but every one I looked at, it was talking about this drug or the effects of smoking this product. And there was on one of them, and I'm going to quote this almost verbatim, but there were a few words in there that I had to leave out, adjectives. But it says, salvia is a funny drug. It's legal for now, and it makes you trip for like 5 minutes. Most people do it once and learn their lesson. The only enjoyable thing about salvia is watching your friends do it for the first time. Of course, I feel like that if that was my friend, that wouldn't be a friend for very long. Another quote, when it had the video showing this young person, it says, "This is one of our friends tripping on salvia for the first time. Can't believe this stuff is legal." Now, this particular product has been is in the process of legislation being passed, or legislation has been passed to make it illegal in 9 states. The U.S. Air Force has looked at this, and they have passed, as part of the illegal objects on Air Force bases, the salvia divinorum plant that has the chemical divorium A in it. Now, this legislation only makes it a misdemeanor. It doesn't carry it any further. There's some of the people in the prosecuting business and all that feels like that we should maybe have gone further. That especially in subsequent cases of being charged under this statute that they would be subject to felony charges. But I didn't go that far at this time. I feel like that we need to start making some steps to stop it from being available in Georgia. It's available in almost every head shop that there is, from South Georgia all the way to the mountains of North Georgia. And I'll be glad to try to answer any questions about this in the Regulated Industries Committee that we heard this in on the Senate side, knowing the Health and Human Services Committee. We actually played about a 4-minute DVD showing a lot of people being interviewed, and we had testimony from a counselor that has worked with some people that's been involved with this, but I did not try to bring those type people before you today. I know in essence the time we're getting short in the session, so I'll be glad to try to answer any questions, Mr. Chairman.
Right now, this is not illegal in Georgia.
No, sir.
And the plant, you say, is widespread.
This particular plant is only grown in the mountainous areas of Mexico that has this particular chemical base in it.
Is it not in all Salvia divinorum plants?
No, sir.
But it is sold, ma'am, Chairman.
Yes, Vice Chairman Moffitt.
Is it Salvia divinorum sold for the flower purposes?
Yes, some salvia, a lot of salvia that we're familiar
I'm
with.
talking about this particular one.
No, sir. No, sir. It's a woody type plant that grows only in the mountainous area of Mexico. This is not the salvia plant that we all have in our yards or we have growing around the Capitol. And it excludes it in this legislation. It says that plant that is grown for ornamental and decorative landscaping purposes is exempt.
Okay. Questions from the committee? Representative Bearden.
Is there a move going on to schedule this drug?
At the current time, the federal drug and FDA, they have looked at it, but they looked at it 3 years ago and did not take action to put a schedule on it.
And you also said there's 9 states looking at making it illegal, or it's 9 states made it illegal?
There are 7 states, I think, that have voted legislation in, and 2 others are considering it besides Georgia. This piece of legislation is actually patterned to put into our code section after what was done in Tennessee last year.
Thank you, sir.
Representative Beard. Y'all look a lot alike, and
it's been a long day, Mr. Chairman, and I'm glad that we can get a little liveliness to this committee.
Wakes us all up. Senator, I'm trying to understand. I know that there's obviously a difference between the 2 plants that we're talking about, salvia, because I have it in my yard. Now, it is grown in the mountains of Mexico, so is it here in the United States right now?
Yes.
Who's growing it?
They're growing it in Mexico, and they're shipping it here.
But who's buying it? Landscapers or?
No. This is shipped here in a dried state. They're not shipping the plant.
Oh, okay.
They're shipping the leaves off of the plants. They're drying them. They're shipping them here. They're sold in Ziploc type bags at the head shops. You can buy it over the internet. If you go to there are 2 or 3 websites that you can go to and buy it. And I mean, it's amazing at what the cost of it is. It's not cheap. And you can test those plants to find if it has this chemical in it. And the salvia we grow as landscape ornamentals do not have that chemical in it. So you can't be confused. I mean, the plant can be tested. If it has the salvia chemical in it.
Further question?
Yeah.
Or more of a statement, I think. Constantly people are finding new ways to use plants and other sorts of things for drug purposes, and I mean, we still have not even close to achieving the major big-time drugs, and now we're trying to stop this plant. Is this going to help stop any kind of illicit drugs coming to the United States?
Representative, no, it's not. And let me tell you, there's a little hidden problem here, too, that when we look at this plant and we look at the normal test on people from the standpoint if they use marijuana, if they use cocaine, that you can do a urinalysis test to see if they have that in their system. This does not show up within the system, the human body system, as far as being able to determine if they've used it. So a lot of people that are put on probation or parole, and as a provision of that, they have to be tested, have a urinalysis test on a weekly basis or whenever asked. They can smoke this, get that quick high, and it does not show up. This is in the very infant stages of this whole country looking at the problem that this is causing. The U.S. Navy has now listed it as banned substances for the U.S. Navy. I mean, it's a problem that really was not out there until 2002. And this product has been used by the Indian tribes for centuries, and it's used in a lot of ceremonies with the Native American population. Not in this country, but in Mexico especially. So what we're looking at here is Georgia having an opportunity to put a minor penalty for somebody, but to try to stop the availability and the use of this before it gets to a point that it becomes a real problem. And it's a worse problem than we really kind of think it is.
Chairman Knox.
Do animals eat this weed? I mean, where it grows naturally?
Mr. Chairman,
I guess it doesn't grow in this country, is what I hear.
No, sir. No, sir. It grows in the mountainous area of Mexico.
Do we have any information from law enforcement in Georgia, Senator, that indicating the extent to which this is a problem here yet?
No, sir. The district attorney's office in Albany, Georgia, District Attorney Ken Hodges, Ken had volunteered that he'd come up because they're seeing a lot of this in the Albany, Georgia area. And it's becoming more and more prevalent that it's being made available, sold, and used. Until you have a case of something that's tragic, people don't really realize it. One of the things kind of brought this to light. There was a young individual that it can't be proven, but his parents feel like that his smoking of this caused him to commit suicide, and this is one of the things that kind of has driven a lot of concerns about this in a lot of areas.
Representative Byrd.
Wouldn't we be highlighting this to make it a bigger issue than it already is if we really don't know what statistics are?
Representative, I think it's already been highlighted when Fox News did a 4-minute program on it and interviewed a University of Georgia student, and he told of his experiences. And as you go on YouTube, you get that many videos that have been posted on there showing predominantly young people that are using this. I don't think there's a question that it's already out there. They know it's available. They're buying it. We just don't have a way to know how much.
What about poppies? I mean, we give out poppies. I think it's the American Legion that gives it out once a year, poppies, and we have poppies going out on the interstates and things like that. Is that something we should start?
No, ma'am. I support what the American Legion does, but the product that comes from those poppies is illegal. They're beautiful plants, and what I'm saying here is that the product that's come from it takes a process to dry it, and then somebody's got to market it. It's not that it's just growing. And I feel like that this is a step, and it would be the first step, and it's a misdemeanor. And if what I perceive as a problem, some people may not, but I think that this is an effort to slow down that problem.
Further questions? Further questions for the author? What's the pleasure of the committee? Vice Chairman Mumford.
Mr. Chairman, I'd make a motion at this time to table this. I think this is a good piece of legislation. I'm glad that Senator Bullock brought it. I think it is important, but I think we need to wait and let the Federal Drug Administration take some action on this plant before we get involved. I don't think that the people on this committee are qualified really to decide. I think we need some expert assistance to determine whether this is a serious drug that needs to be regulated. If the federal government looked at it 3 years ago and did not regulate it, I don't really know that we need to start regulating it now. Maybe next year when there's more information we'll have a different position, but I'd make a motion to table at this time.
Second.
Is there a substitute motion?
Can I make one?
Well, I'm trying to help you.
I know you are, Mr. Chairman, and I appreciate that.
I'm fishing for a substitute motion, and I'm not getting a bite. Representative Bearden?
Substitute motion that them deemed illegal in 7 states, and apparently there is a problem with this. The motion do pass.
Have a motion. Is there a second to Representative Bearden's motion? Is there a second?
I tried, Senator.
Is there a second? Is there a second? I think the Bearden motion will die for lack of a second. Which leaves us with the Mumford motion, which could be worse.
I understand.
That we put Senate Bill 295 on the table for the time being and study it further. Representative Bearden, discussion on the discussion on the Mumford motion.
Just trying to help the process at a later date. If we could bring some highlights of the 7 states that did make it illegal and some of their findings to share with the committee, maybe that would help move this process along and go with from there. But that may just be something in the future that might be able to assist us.
Any further discussion before we vote on the Mumford motion? All in favor of voting on the Mumford motion to table Senate Bill 295 indicate by raising your right hands. All opposed? 1. Okay.
Thank you, Mr. Chairman.
Thank you very much, Senator.
If y'all will excuse me, I got my ag committee meeting going on. So. Thank you.
Okay, we're down to one bill, and that is Senate Bill 249. Senator Whitehead, I understand, cannot be here. Representative Alan Freeman is handling that on the floor of the House. He could not be here. So I think we're going to have, is Terry...
Mr. Norris is here.
Sorry, back here. Terry Norris. I have given permission for Mr. Norris and the Georgia Sheriff's Association to handle this bill. And are we operating from the committee sub? You have it?
Yes, sir, I do have a copy of the committee sub.
Okay. And that is what we're operating from?
If it is the, yes, sir.
Do you have a question about that?
I have a question about it. I don't know where the committee sub came from, and is that yours?
Yeah.
Okay. Never mind. I don't have any other questions.
Thank you, Mr. Chairman and members of the committee. My name is Terry Norris. I'm the Executive Vice President of the Georgia Sheriff's Association, and appreciate the opportunity to speak on Senate Bill 249, which was requested by Georgia's sheriffs and brought forward in the Senate by Senator Whitehead. And if I may just speak in general terms, bless you. Okay. Trying to give you an opportunity. If I may just speak in general terms, I would like to say that the substitute will make it clear that sex offenders cannot claim their address as a vehicle. It will specify that sex offenders cannot reside, work, or volunteer within 1,000 feet of a state-licensed child care facility. It will offer up provisions which will comply with the federal Adam Walsh Act of 2006, which requires sex offenders to register in multiple counties if they work or go to school outside of their county of residence. Those provisions also require palm prints be taken of all sex offenders. The substitute, I think, requires that the Georgia Department of Corrections notify sheriffs 30 days prior to the release of offenders of this registration information. And if I could stop now and ask that that 30 days be reduced to 14 days. I've talked with corrections and others at the state. Sometimes the Department of Corrections is not aware of a release. If it's a parole release, more than 14 days ahead, so they wouldn't have that information to pass along. It makes clear that sex offenders must report in person to the sheriff in the counties. It allows the sheriffs to electronically update changes to the local sex offender registry within, I think the substitute addresses 2 business days. It specifies that the sheriff in the county of the sex offender's residence is the primary law enforcement official for purposes of communicating the residence of the offender and any other changes to other sheriffs. It prohibits sex offenders from working or volunteering at any child care facility, school, or church, or at any business located 1,000 feet of those locations where the offender actually performs the work or performs the volunteer services. And I think that, is that included in this particular language? I hope so. That volunteer aspect of this provision is very important. And finally, specifies that the measurements of from the residence of a sex offender to restricted area are calculated from the property. So really there's no change in that particular provision in the law. That's a summary of the changes, and I think those those issues are reflected in the current substitute.
Questions for the presenter, Representative Benfield.
Thank you. I just have one question. Section 9, dealing with the open meeting, is that consistent with Georgia's open meeting laws? Are you allowed to close the meeting for risk assessment classifications?
It is late in the day. I'm sorry you're listening to a layman. I'm not aware. I would presume it is.
Chairman Knox.
Well, I'm not sure I understand how, in the case, for instance, of somebody who's maxing out on their sentence, how are you going to make, how can you make them tell you where they're going to live if they don't know, for instance, before they're released from prison? I mean, you can't not let them go. What if they don't know where it is and tell you, I don't know where I'm going to be. I'm just going to leave here and, get on a bus and stop the first town I come to. How can you enforce this is what I'm getting at?
Most inmates, I think, know where they're going, particularly if they're not maxing out. If there's a parole plan for them or they're released to probation supervision, they would provide a prospective residence plan for that person. There is, however, Mr. Chairman, occasions where an offender does not know where he's going. And it has come to our attention recently that the counselors in the prison system work to facilitate some sort of residence plan for that inmate. It's not foolproof, though.
Okay, but we're here proposing this law to say they've got to tell us where they're going to go, where they're going to be living 14 days, or well, it's 30 days before they get out of prison. In the case of a person that served their sentence, all they got to do is tell you where they're going to be when they're there. I mean, they don't have to. There's nothing that you can do to force them to do that. They're not under the authority of the Department of Corrections anymore at that point when they serve their sentence, even though they're going to be on the registry. So I just don't know how you're going to do this. I don't know how this works. And how are you going to require the Department of Corrections to comply with the law, much less the individual, the defendant?
And as a partial answer to that, the current law already requires this notification prior to their release. It already requires that in the current law. What we're trying to do is get a little bit of lead time if we can.
I understand that, but even the current law is probably not enforceable either. We said that when we were going through 59, that, I mean, that's all fine and dandy, except you just can't do it. And so I don't know why we want to compound that. Well, let me ask you, if I can, Mr. Chairman, a further question. With regard to palm prints, we already going to have their fingerprints and their photograph and their DNA and just about everything else. Why do we need their palm prints at this point? And isn't that going to require purchasing more equipment?
No, sir. It won't require that, but it will require the taking of that print, which I am told by the experts is a more readily available print at many crime scenes than just the fingerprint. It's more easily identifiable. And also, to further answer the question, we're not going to have a lot of choice in this matter under the Federal Adam Walsh Act. That is part of that federal act.
So the palm print's required by the federal act?
Yes, sir.
Thank you, Mr. Chairman.
Representative Levitas.
I'm sorry. I'm not sorry that I missed the fireworks last year, but I'm sorry that I may lack some institutional history on this bill. But I'm a little bit confused by the change about the vehicle. What happens if somebody lives in an RV or a mobile home? I'm just wondering, is vehicle defined to not include that? Because I guess what I'm wondering is, would they be in violation if they lived in a mobile home or an RV?
Our answer is no to that question.
Well, I guess my question is, I guess, or should have been, isn't a recreational vehicle or a family motor coach, isn't that a vehicle? Because if it is, it seems to me that the offender would not be allowed to use that. And my only concern with regard to that, because believe me, I'm in favor of registering sex offenders, is whether we would be encouraging them to lie about where it is they live if an RV is where they live or family motor coach is where they live, but they're not allowed to use that as their residence. And therefore it might make it harder for you guys to keep track of them.
I believe the motor vehicle provision is important, even if that is the case, because the intent here is to identify a specific residence. If you live in a motor home, that is not a permanent residence if it is moving around. So the intent for this legislation is to address cars, trucks, those types of vehicles. To answer as to whether a motor coach or a motor home is a motor vehicle in the current law, I would presume it is, but again, we do not want to see individuals living in any sort of vehicle which is mobile. Now, you all, in the last year's session under 1059, you all said homelessness is not an address. And this section C on page 2 of the substitute, at the top of the page, paragraph C, I should say, that language is stricken under this particular piece of legislation because that was somewhat confusing. We were telling individuals you couldn't live in a motor vehicle, yet this particular provision was in the law and sort of said, if you do, you've got to provide this information. So it is intended to sort of simplify and clear things up, but obviously it is not doing so.
Mr. Chairman, may I follow up?
Sure.
And again, please understand that my intent is to help keep track of these folks, not to in any way adversely affect the bill. But, you know, in the car and the truck, I definitely understand, because that to me comes much closer to an active intent to deceive or but if there's somebody who's living in a kind of vehicle that might be mobile, but they live in an RV lot, that's where they live. Again, my only concern is, are we having the unintended consequence of maybe losing track of folks we could otherwise keep track of, because they're having, by law, they're not able to say that they live where they actually live. And again, I agree with you about the other stuff. I mean, at a certain point, you have to draw the line. I don't have no desire to get in the way of this bill to prevent these guys from being tracked, and if that's what it does, I'll withdraw the amendment. But I'm just concerned that we may have that unintended consequence, and if there's an easy way to fix that, that'd be great. And if that's not what the authors want, then I just think we're passing that with the risk. We just need to be understanding that that's a potential risk if we're passing this legislation on.
Yes, sir. Thank you.
Chairman Knox.
I want to follow up, Mr. Chairman, again on the palm print issue. Your explanation sounds like a good explanation. I'm wondering, though, do we have the equipment and do we have the technology? Are we going to have to come up with some money for both? Do we have current technology to do palm prints?
My understanding is we do, sir.
And pass it back and forth between the sheriff and corrections and so on? Okay. And they have the equipment to do that with?
Yes, sir.
And y'all, sheriffs, all have the equipment to do that with?
Yes, sir.
Thank you, Mr. Chairman.
Representative Benfield.
Thank you. I want to come back to my open meetings concern, and I just have I'm always wary whenever we close meetings to the public or close records to the public, even when it's for an extremely valid purpose, and certainly safety of our children is a laudable goal. But I'm concerned about the wording of the change. This is creating a new exemption. I pulled the code. There are currently 9 exemptions in the law to public meetings, and this would be creating a completely new exemption to our public meetings laws. So I think we should be aware of that. But the way it reads, it says, the deliberations of the Sexual Offender Registration Review Board, and in addition, and perhaps lead counsel can enlighten me if I'm coming to the wrong conclusion, but the way I read that is all deliberations of the Sexual Offender Review Board shall be closed to the public, not just those specifically related to receiving information or evidence relating to risk assessment classifications, if there's a substantial risk of harm or injury to a witness. And I was looking at some of the other language in the exemptions, and the language I like would be meetings of the Sexual Offender Registration Review Board when such board is discussing information or evidence, and then go on to the way it's written in the proposal. But the way I read it, it's a blanket exemption from all deliberations of the review board, not just those specifically related to risk assessment. So I would like to see that language, and I invite Jill, although I don't want to put you on the spot, to help with some wordsmithing so that it's narrowly tailored to get at the risk assessment classifications, which my understanding is what you're trying to exempt, not all deliberations.
Okay. That was me. Sorry. Did you want to?
No, I have no problem with that. I think that is the issue that we're probably trying to address here.
Okay. Further questions or comments?
So that'd be appropriate time. I do have.
Yeah, I want to. We've got one witness and get our questions out of the way. Questions or comments?
I just want to thank Mr. Norris for bringing this bill. I know he's worked real hard on it this session. It's been very difficult to work on it. I appreciate your labor and the Sheriff's Association's labor in this matter.
Thank you, Mr. Chairman. Thank you, members.
Sarah Tanichi. I'm sorry.
That's okay.
Vice Chairman Mumford always has to remind me.
I'm glad you have him around.
I am too, most of the time.
Thank you, Mr. Chairman, members of the committee, and I ask for your patience with me with my voice. I think my cold medication wore off somewhere around the pot lollipop discussion. But I just want to offer a few comments about this bill, and actually I want to address the version of the bill that passed out of the Senate, not the committee sub that's on the table today, which actually, for Mr. Norris's benefit, it does no longer include the volunteer provision, which might be problematic as well. There was a provision in the original bill that created an exemption for people who are senior citizens who are living in nursing homes or who are under hospice care to petition the courts to be relieved of the residency restrictions. This doesn't mean that they wouldn't be on the registry anymore, that they wouldn't be supervised, but this would allow for them to not be evicted from their nursing homes because their nursing home happens to be within 1,000 feet of one of the prohibited locations. My office, which is the Southern Center for Human Rights, represents a class of everyone on the registry and a challenge to the 1,000-foot restrictions. We received calls last fall from the director of a nursing home who was telling us about 3 of his patients. One was a hospice patient with 2 months to live. One man was so physically disabled by brain disease that he couldn't walk or talk. One had Parkinson's disease. He had already had 2 strokes and was in a wheelchair. And the reason that this director of the nursing home called us was because sheriff's deputies had come to this nursing home and said that all 3 of these patients would have to be moved. It didn't matter that none of these men could even walk across the room. Georgia law provides no exemptions for these individuals. I'll give another example, and actually...
Let me make sure I understand what you're saying. What you're saying is that in that regard, the Senate Bill 249 dealt with that issue. Is that correct?
That's correct. We worked with Chairman Whitehead in including that, and that was a provision that he felt...
Would you rather have Senate Bill 249 or the substitute if the idea is that perhaps the only thing that's going to pass this House is the substitute?
There isn't very much left in the substitute that's worthwhile to my organization.
Okay.
But I also appreciate the challenges that the sheriffs are facing, and I also commend them for bringing this issue forward. There's a lot of problems with this bill, some of which have already been mentioned in this committee.
I know of a case similar to the one you're talking about where a gentleman he was moved from one VA hospital to another one because of prior law, and then subsequent to the law passed last year, now can't live in a VA hospital, and he's completely bedridden.
That's right. And I know this has been a long day, but I just want to share with y'all a very specific example.
Wait a minute. You got a question over here.
Before you move on from the senior and the hospice care.
My reading, and correct me if I'm wrong, of the provision, I've got the version as passed the Senate, is that the exemption for the seniors or persons in hospice care and permanently disabled persons only applies if a judge has reviewed it. So there is a check. It's not an automatic exemption. There is a judicial check before that exemption is applied.
That's correct.
Okay. Thank you.
I just want to tell you about, I passed around these pamphlets that we have, and I want to tell you specifically about this man. His name is Daniel Anderson. He's on the sex offender registry because years ago he was convicted of statutory rape. Now, however, he has advanced Alzheimer's disease. He's losing the power of speech, and he doesn't recognize his family members, including his 77-year-old wife, who is his only caretaker. Because the current law has no exceptions, we had to go to court and obtain a consent order to prevent the eviction of this man from his home. It was on behalf of him and 8 other individuals. One of the men we got the injunction for has already passed away. Because under 1059, the General Assembly enacted a provision that requires everyone on the registry to be on there for the rest of their lives, this sort of problem is only going to continue to grow as the years go on. I don't know that I don't know that any sheriff relishes the task of going to a nursing home and telling the director that they have to throw a dying person out onto the street. And I also fear that, well, right now there's the provision regarding the bus stops that people on the registry can't live within 1,000 feet of bus stops. This provision is on hold right now because of a federal court case.
This bill doesn't affect that.
No, it sure doesn't.
Neither one of these bills affect
it sure doesn't.
Correct.
But I want to give you an idea of what will happen if that does go into effect. As we know right now, people already are having a hard time doing this. In particular, the people we're concerned about are the folks in the nursing homes. Just to give you an idea, I know this is a little hard to see, but this is a map of DeKalb County, and the areas that are this light yellow color are the areas that are off limits without the bus stop provision to people on the sex offender registry. This is DeKalb County off limits to people on the sex offender registry if the bus stop provision goes into effect. So essentially, there will be nowhere in DeKalb County for people on the registry to live. Sorry, I'll turn it this way. It goes from this, the yellow versions are prohibited, and this is the full, if the bus stops go into play. I would respectfully urge you to include the language that creates an exemption for these extremely old and extremely ill individuals. The language is in the version as passed the Senate. I believe it starts on page 5, line 33, and it goes through page 6, line 11. Yeah, I would just urge the committee to include that language if they do choose to pass this bill.
I'd like to direct a question to Mr. Norris. Is that the only thing that was taken out of this committee substitute, or are there other changes?
There was under the current law, these individuals register whether they're incarcerated or not, and that provision was removed. So it would remain under the current law, which requires those incarcerated to meet the registration requirements in some way, and that has been problematic for us if we want to follow the letter of the law. If you've got 300, for instance, 300 people that are sex offenders housed in Jackson Diagnostic Classification Center in Jackson, Georgia, the sheriff, he cannot comply with the law for those individuals to show up personally and to register, and nor can.
And on their first offense, it's 1 to 10, and on their second offense, it's life in prison.
Technically, it's a felony, yes, sir.
You got anything else you want to say? What's the pleasure of the committee? Yes, ma'am.
Can we ask Mr. Norris, do you have an objection to this language being
restored with the judicial exemption for disabled and elderly? Okay. Then I have a couple of amendments.
It might be easier to move the passage of SB 249.
Except it doesn't have that exemption for the open meetings.
That piece and the section following it are both new sections in the substitute. One deals with victims identifying information, and then there's the section that you were concerned about.
So they wouldn't even be there.
Mm-mm.
Okay. Do we want to change the business? Wasn't it 30 to 14 days? There was a page 2, line 26. I'm looking at the as passed the Senate.
I'm wondering if we could just get it passed exactly the way the Senate passed it and see what happens.
Well, there was concern about the 30 days.
Is it 30 days?
It was 30. We asked that it be
Changed to 14.
But the Senate passed it as 30.
They did pass it as 30.
That's longer than what was in it, but the rest of them changed it. Do I have a motion? I was asking if I had a motion. I don't know if I want your motion. Yeah, go ahead.
Passage 249, CSFA, last one.
Is there a second?
Second.
What do we do?
Just made a motion to pass 249.
Pass out the Senate.
Has it passed the Senate?
Yes. Is there a second?
Second.
Who's presiding, you or me now? Yes, sir.
I'll make a motion to table.
Got a substitute motion?
Motion to table.
Is there a second?
Second.
Have a substitute motion to table Senate Bill 249. Is there discussion? Is there discussion?
Well, I just have concerns about these people who are permanently disabled or the seniors who are now being forced to leave their care homes. I want the exemption, judicial exemption that this bill provides. If we table, does that mean, are we going to meet again this session?
Representative Benfield, I'm going to be very honest with you and tell you that I had not intended to when we started today's proceedings. And I still hope that we don't, frankly. But I don't know the answer to that because I keep hearing that the adjournment schedule may adjust. And were that to happen, then I don't want any. Well, let me give you a fair, I think a complete fair answer. Do not vote. Do not base your vote on us meeting again on this. Don't let whether we would or would not influence you. We have a substitute motion that we table Senate Bill 249. Is there further discussion? Representative Benfield.
I'll be brief.
I know the hour's late and I've got to pick up my daughter, but I would just argue against this. I think that there's a lot of work that's gone into this by the sheriffs to make this enforceable. I had a lot of concerns with the original bill that it was difficult for our law enforcement to enact, and I think a lot of work's gone into this, and I appreciate the efforts that Sarah Tatanchi's group has made, and I think it's important to have that exemption through a judge for people who have legitimate, permanently disabled and elderly, extremely frail individuals. So I would vote against the table and move for Representative Bearden's motion. I support his motion. Thank you.
I'm going to withdraw my second.
To
the
motion to table.
Motion to table.
Well, since you're my subcommittee chair, I will let you do that. Now, so the Mumford motion to table is now back on for a second if someone wants to second it. Is there a second? Is there a second to the motion to table? Hearing none, that puts us back to the Bearden motion to do pass the original form of the bill, the Senate version. Is that what your motion was?
It was, yes, sir.
Is it still?
Yes, sir.
Okay. Any further discussion? Hearing none, all in favor of the motion to do pass Senate Bill 249 in the version that the motion described, please indicate by raising your right hands. Three? Oh. All opposed? Motion is carried. It will be reported to the Rules Committee appropriately, and that concludes today's meeting.
Thank you. Except
that we have one remaining item of business, and that's our committee picture. Not today. No, not today. We're not doing that today, but I will be calling you off the floor, maybe even tomorrow if Diana will remind me.